gentlemen, welcome, and thank you for joining today's FOIA Advisory Committee meeting. Before we begin, please ensure that you have opened the Webex participant and chat panels by using the associated icons located at the bottom of your screen. You are welcome to submit written questions throughout the meeting, which will be addressed at the Q&A sessions of the meeting. To submit a written question, select all panelists from the drop-down menu in the chat panel, then enter your question in the message box provided and send. Please note all audio connections are currently muted and this conference is being recorded. To ask a question via Webex audio, please click the raise hand icon on your Webex screen, which is located above the chat panel on the right, to place yourself in the question queue. If you are connected to today's meeting via phone audio, please dial #2 on your telephone keypad to enter the question queue. If you require technical assistance, please send a chat to the event producer. With that, I will turn the webinar over to David Ferriero, Archivist of the United States. Sir, please go ahead.
Thank you, Michelle. Greetings from the National Archives flagship building, which sits on the ancestral lands of the Ncmd peoples. It's my pleasure to welcome you to the 6th meeting of the 2020-2022 term of the Federal Freedom of Information Act Advisory Committee. And I'm pleased to welcome our newest member to the committee, Dion Stearns of the Federal Trade Commission, who I appointed last month to fill the vacancy created by the resignation of Lubna Haddad of the Defense Intelligence Agency. Thank you to Lubna for serving on this 4th term of the committee. And thank you, Dion, for rolling up your sleeves for the last 7 months of this term. The committee's charter notes that in addition to developing recommendations for improving FOIA administration, the committee also should develop recommendations for improving proactive disclosures. I understand that the Technology Committee is building on the work of the 2016 to 2018 term of the committee, which offered 11 types of records to prioritize for proactive posting. Here at the National Archives, we take seriously FOIA's mandate to proactively post records of general interest. You may have heard news in the last couple of weeks about the role of the National Archives with regard to presidential records and executive privilege, for instance. I invite you to visit the online National Archives FOIA reading room at archives.gov, which contains dozens of letters related to the request for presidential records by the House Select Committee to investigate the January 6th attack on the U.S. Capitol. Other selected records available on our website include records related to my task force on racism, which I convened in 2020 to recommend changes in support of an equitable environment for all National Archives customers, internal and external. Also on our website are FOIA logs, an employee locator, and an organizational phone list, among many other records frequently requested under FOIA. These postings set a great example for proactive disclosures across the government. Committee members, I look forward to hearing about the ideas you all have been shaping since the September 9th meeting on a range of FOIA matters, including FOIA funding, first-party requests, and the agency's use of the so-called Glomark response to neither confirm nor deny the existence of records. Today marks the 8th virtual meeting of the FOIA Advisory Committee, which last met in person on March 5th, 2020, when those of us in the William G. McGowan Theater here at the main Archives building refrained from handshakes and used copious amounts of hand sanitizer. 21 months later, after the pandemic turned our world upside down, we continue to face uncertainty as to when we might meet again in person. For the time being, I wish you continued resilience as the days grow shorter between now and December 21st, and happy holidays with your families and loved ones. Finally, if you have not already watched the National Archives Foundation's recent event with former FOIA Advisory Committee Margaret Quokka discussing her book, Saving the Freedom of Information Act, I urge you to watch the National Archives YouTube channel. Longtime FOIA Advisory Committee Tom Sussman interviews Professor Quokka about the role that FOIA plays in fostering dramatic accountability and transparency. I now turn the meeting over to Alina Simo.
Thank you very much, David. Good morning, everyone. As the Director of the Office of Government Information Services, OGIS, and this committee's chairperson, it is my pleasure to welcome all of you to the 6th meeting of the 4th term of the FOIA Advisory Committee. I hope everyone who's joining us today has been staying healthy, safe, and well. I want to welcome all of our committee members today and express my continuing gratitude for your commitment to studying the FOIA landscape in order to develop recommendations for improving the FOIA process government-wide. I especially want to welcome Dion Stearns of the Federal Trade Commission. As David noted in his welcoming remarks, he appointed Dion last month to fill a vacancy created when Lubna Haddad of the Defense Intelligence Agency took on new work responsibilities and resigned from the committee. I do want to thank Lubna for her work on the committee and particularly her work on the classification subcommittee. Dion is Assistant General Counsel for Information at the Federal Trade Commission, the FTC, whose headquarters sits right next to the National Archives flagship building in downtown Washington, D.C. Prior to joining the FTC, Dion fulfilled a variety of FOIA and Privacy Act responsibilities at the Department of Justice's Executive Office for United States Attorneys, EOUSA, and the Office of Information Policy, OIP. Her experience ranges from processing FOIA requests to serving as agency counsel in FOIA litigation to training senior officials on FOIA. Dion is a graduate of Howard University and Catholic University's Columbus School of Law. Dion has already jumped into committee work by attending all 4 of the most recent subcommittee meetings. Dion, thank you for that. And she is deciding which subcommittee or subcommittees she will join. I told her there's no limit. Welcome, Dion. We are very glad that you are here. I also want to welcome our colleagues and friends from the FOIA community and elsewhere who are watching us today, either via Webex or with a slight delay on NARA's YouTube channel. So some housekeeping rules and announcements that we always go through at the beginning. Committee members, please bear with me. First, I would like to introduce our fearless leader, the committee's designated federal officer, DFO Kirsten Mitchell. Kirsten's going to help make sure that I stay on track today, as always. Kirsten has taken a visual roll call, confirms that we have a quorum. We expect Tuan Samahon to join us a bit later today, and I'm advised that Tom Sussman will have to depart the meeting at approximately noon, but he may be able to call back in, so that would be lovely. A few words about public comments. We have received several written comment submissions in advance of today's meeting. We have reviewed all of them carefully and evaluated them prior to posting them to ensure they satisfy our posting policy for public comments, which is available on the FOIA Advisory Committee website. We have posted these public comments after remediating them to ensure they are compliant with Section 508 of the Rehabilitation Act. We have received so many public comments that we are still in the process of going through all of them. Even if there are any comments that we decide not to post, we will nevertheless share them with all committee members. And I want to specifically invite our committee members to review the public comments we have received thus far, if you have not already done so. I also want to note that the chat function in Webex or the NARA YouTube channel is not the proper forum to submit extensive public comments. You may submit public comments at any time by emailing us at foia-advisory-committee@nara.gov, and we will consider posting them to the OGIS website. The chat function on both platforms should be used to ask clarifying questions or provide brief comments or questions that we will consider reading out loud at the end of today's meeting. During our public comments period, we are particularly interested in soliciting feedback on the issues that the 4 subcommittees are currently considering. Committee members are interested in hearing your ideas and feedback so that they may integrate these into their internal discussions as they develop their recommendations for this committee term. I would like to briefly address one comment we received, that we post a list of all attendees, government and non-government, for our FOIA Advisory Committee meetings, just as we do for all Chief FOIA Officer Council meetings. We have considered this request and have decided not to do so. The FOIA statute itself requires that detailed minutes of the Chief FOIA Officer Council meetings be kept and contain a record of the persons present. There's no such statutory requirement on either FOIA or the Federal Advisory Committee Act, under which this committee operates, or the Government and Sunshine Act. Therefore, we will not be posting a list of meeting attendees, either government or non-government, for our FOIA Advisory Committee meetings. Meeting materials for this term, along with members' names, affiliations, and biographies, are available on the committee's webpage. Click on the link for the 2020 through the 2022 FOIA Advisory Committee on the OJA's website. Please also visit our website today for our agenda. And regarding our agenda, today we have no outside speakers, nor do we know exactly how much time each agenda item might take, particularly with regard to some of the draft recommendations that we'll be discussing today. And as chairperson, I reserve the right to adjust the times as necessary. We will upload a transcript and video of this meeting as soon as they become available. A reminder that the FOIA Advisory Committee is not an appropriate venue for concerns about individual FOIA requests. If you need OJA's assistance, you may request it, but we ask that you not do so through our committee email. It is hard to believe that we've been meeting virtually for the last 21 months. While the virtual environment has allowed us, all of us as committee members, to attend with greater ease, regardless of geographic location, a big disadvantage for me and Kirsten is that we're not always able to see committee members raising their hands or leaning forward to ask a question or make a comment as we would if we were meeting in person. So I will be doing my best to monitor committee members' nonverbal cues, and we all need to be respectful of one another, try not to speak over each other, although I know that's inevitable. But I also want to encourage committee members to use the all panelists option from the drop-down menu in the chat function when you want to speak or ask a question, and you can, I will call on you at that time, or you can also chat me or Kirsten directly via chat. As a reminder, however, in order to comply with the spirit and intent of the Federal Advisory Committee Act, committee members, please keep any communications in the chat function to only housekeeping or procedural matters. No substantive comments should be made in the chat function, as they will not be recorded in the transcript of this meeting. Another housekeeping reminder, if you need to take a break, please do not disconnect from audio, video of the web event. Instead, just simply mute your microphone and close your camera, and send a quick chat to me and Kirsten to let us know if you'll be gone for more than a few minutes, and join us again as soon as you can. We have noted a 15-minute break at approximately 11:20 a.m. on our agenda. We may break a bit earlier or a bit later, depending on our pace today. And just a reminder, I'm always guilty of this. Please remember to identify yourself by name and affiliation each time you speak. This will help us down the road with both the transcript and the minutes, both of which are required by the Federal Advisory Committee Act. So with all of that, any questions? You've heard me give all these instructions before, so there should be no great surprises. I would like to turn my attention now to approving the minutes from our last meeting, which was September 10th, 2021. Kirsten emailed committee members the minutes from that meeting. I apologize, September 9th, not 10th. I misspoke. Under a 90-day deadline laid out in the Federal Advisory Committee Act, she and I certified the minutes to be true and correct and posted the minutes earlier this week. But committee members, if we missed anything, please let us know and we will make any corrections as necessary. So at this point, do I have a motion to approve the minutes, unless I hear any objections from anyone?
So moved.
Okay, do I have a second?
Second.
Thank you. All right, all in favor, say aye.
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 All right, any objections? Okay, minutes are passed, and they are posted on our website for your viewing pleasure. Okay, any questions before we get started on the substantive part of our meeting today? Anyone have anything concerns or questions that they want to ask before we get started? Okay, not hearing anyone. If we could please move the slide deck, Michelle, to the next slide. Okay, so first up today, we always like to switch things up, keep everyone on their toes. The classification subcommittee is going to be presenting first. Kristen Ellis and James Stoker are the classification subcommittee co-chairs. They've been hard at work. And I'm going to turn the floor over to James and Kristen.
Thanks, Alina. This is Kristen Ellis. I am an attorney with the Federal Bureau of Investigation, and I am a co-chair of the classification subcommittee with James Stoker, as Alina mentioned. And our other committee member, we are a very small committee, is Cal McClanahan. The focus of our work over the past year-ish has been, a focus has been Glomar responses, particularly those issued in national security cases. A Glomar response is one where the agency neither confirms nor denies the existence of responsive records, because doing so would itself reveal some information that is exempt from disclosure under the FOIA. While the FOIA statute itself does not contemplate a Glomar response, courts have recognized it as a legitimate response to a FOIA request under certain circumstances. However, there is some public skepticism about the use of Glomar responses. This may be driven in part by a lack of publicly available data about the use of Glomar responses, including the frequency and circumstances under which they may be issued. So the subcommittee has prepared a report that has been circulated, I believe, to the full committee, making recommendations designed to improve transparency and understanding about the use of Glomar responses. And James is actually going to go through those recommendations, but before I turn it over to him, I wanted to take a second to thank Kirsten Mitchell, Alina Simo, Krista Lemlin, and Bobby Talabian for their comments and input on the report, as well as my fellow committee members, Cal and James, for all the work that they've done getting it together so we could present it to you today.
This is James Stoker from Trinity Washington University. Thanks, Kristen, and thanks for all your work as well. As you can imagine, this is a rather polarizing issue in some ways. While generally both members of government agencies and of the requester community recognize that Glomar responses are legitimate and acceptable and appropriate under certain circumstances, there is a significant amount of skepticism from the requester community about the way that they are used. And so our recommendations, which I'm going to go through now, are designed to try to get at some of the sources of this skepticism. So I'm going to go through the 4 recommendations one by one. I think we have them on the slides. Is that correct? So if we could just go to the first recommendation. Okay, here it is. I would note this. I'm going to read the text of the recommendations. Some of them have been slightly paraphrased, I believe, to fit on the slides. So I'll read out the full text of the recommendation as we've made it in our report. We recommend, number 1, we recommend that OIP issue guidance to government agencies that they use the internationally recognized nomenclature of neither confirm nor deny, Ncmd, to refer to Glomar responses. FOIA's purpose is to make the government more transparent and accountable to its citizens, and the use of terms of art or jargon can make this more difficult. We particularly think that the term Glomar itself is problematic. Why? Well, it refers to the name of a specific submarine involved in a court case, and that court case originally had to deal with exemption B1 related to national security. Now, however, nowadays the Glomar response is used in response to many different types of FOIA exemptions, including regarding privacy. And it's also spread beyond the federal level to state and local authorities. So Glomar, as a term, is somewhat misleading. And that can act as a barrier for ordinary citizens and average requesters who are not deeply steeped in the history of the FOIA. The first question that anyone asks when they hear this term Glomar is, well, what Glomar? What is that? And that requires a lengthy explanation. And our impression is that this can act as a barrier to access to basically responding and reacting to Glomar responses. We would note that in practice, the term neither confirm nor deny is used in many places, including in government documentation on the subject. So if you read through the Executive Order on Classification or Department of Justice and OIP guidance on the subject, usually in the text, the term neither confirm nor deny is used. But the term Glomar is also used from time to time, in particular in regards to when referring to court cases. We feel that using the term neither confirm nor deny will help to make the concept clearer to all involved. So we're going to our second recommendation now. If we can put it on the slide. We recommend that OIP require standardized tracking and reporting procedures for Ncmd responses. That is, Glomar responses. And I'm continuing here with our recommendation just to make this clear. Government agencies should be required to track and report on an annual basis the total number of Ncmd responses issued, whether these Ncmd responses were in whole or in part, the relevant FOIA exemptions that justify Glomar responses, and the number of corresponding cases in which these were used. The number of Ncmd responses that have not been affirmed on administrative appeal, and the number of Ncmd responses that have not been upheld in by a court in litigation. We also recommend that the Department of Justice should track and report on an annual basis aggregated data on Ncmd responses as reported by agencies. Congress does not currently require government agencies to track and report the use of Ncmd responses separately from other types of responses. Rather, they are included generally in full denials based on exemptions. At least this is what the Department of Justice through OIP recommends. They recommend that Ncmd responses be reported as full denials. However, our subcommittee was not able to ascertain whether all agencies follow this practice. So there is a lack of data out there about how often these neither confirm nor deny responses are used. Certainly there is an impression that their use is increasing. There has been a term coined for this, so-called Glomark Creep, which refers to the increasing use of neither confirm nor deny responses in federal government, as well as its spread to other branches excuse me, at least to other agencies within government, and to the state and local level as well. Tracking data on the use of Ncmd responses will help the public better understand trends in these areas and their underlying causes. Now, to be meaningful, the data must be sorted and categorized. For instance, some agencies include a partial Ncmd response in response to every FOIA request. If you count this as a single Ncmd response, it will inflate the number of Glomar responses that are actually being used. So for this reason, we believe that agencies should report FOIA data segregated by category, such as whether or not the Ncmd response is full or partial. And then they should also sort the number of Ncmd responses by exemption. However, because we don't feel like we have a good handle on exactly how these responses are used across government, we believe that, at least in the short term, agencies should be allowed a certain amount of leeway in how they report these responses. In other words, they should look at their own practices and figure out what the best way is to report them. In recommendation number 4, we recommend further investigation into the issue of Glomar responses, neither confirm nor deny responses. And we suggest that this be one of the things that the investigation look into as well. However, right now, the subcommittee did not feel comfortable going into too much detail about exactly how these responses should be tracked and reported. We have here on this slide some of the detail, if you all would like to have a look at it, about what we're asking government agencies to track and report right now. We do recommend that the DOJ through OIP include Ncmd responses in its annual summary of agency annual reports, so that there is a picture of how this practice is conducted across government. We can move on to the next slide now. Our third recommendation is that government agencies provide information to requesters on their websites regarding circumstances that will likely result in an Ncmd response, and where possible, recommendations on how to avoid such a response. Government agencies already have a duty to provide the public with information on how they implement the Freedom of Information Act. For instance, there are explicit requirements in place for government agency websites regarding the FOIA. However, government agencies are not currently required to include information regarding Ncmd responses. Some agencies do this already. So for instance, if you go on the CIA website, there's a list of guidelines in its online FOIA reading room that include several mentions of how they use neither confirm nor deny policies. However, there's not a general policy statement on how Ncmd responses are used. For many other government agencies, there's no mention of this at all. So you could file a FOIA request and receive a neither confirm nor deny response, and be totally surprised by it, or not have any awareness that this is a possible response. So we suggest the following guidelines for information be provided in the public. This is not in the text of the recommendation itself. This is in the explanation of it, but it provides some ideas of how agencies could proceed. The agency should attempt to describe all circumstances that will likely result in an Ncmd response with as much relevant detail as possible. The agency should advise requesters on how to avoid an Ncmd response if possible. The information should be clearly written in plain language understandable to a non-expert. And we suggest that an ideal place for such a discussion is in the FOIA reference guide or handbook. We recognize that this will be challenging for agencies, and we can go into this in more detail in the discussion. For instance, if your goal in using an Ncmd response is to avoid revealing information about so-called sources and methods, you may not be able to go in a large amount of detail about what those sources and methods are, because that would actually reveal what the sources and methods are themselves. However, you may be able to discuss the practice to some degree. So we're not getting into too much detail here about what specifically agencies should be doing, but the general thrust of our recommendation is that they should be providing more information than they do now. Okay, we can go on to recommendation number 4. Our final recommendation is that the Archivist of the United States direct a relevant organization, such as OGIS or the Information Security Oversight Office, or if necessary, recommend that a relevant organization, such as the Government Accountability Office or the Intelligence Community Inspector General, first conduct a review of the use and practice of Ncmd responses across government, and second, formulate a set of recommendations to ensure that these responses are being used in a manner consistent with the goals of the Freedom of Information Act. So, as my colleague Kristen may or may not have mentioned, we did attempt as a committee to administer a questionnaire to various agencies that we thought frequently used Ncmd responses. And we particularly, being the Subcommittee on Classification, we particularly targeted agencies that we felt would be likely to use neither confirm nor deny responses in regards to Exception 1B on national security. However, we only received responses from a very small subset of agencies that we sent the questionnaire to. I think, I don't remember the exact numbers, but I think we sent almost 24 questionnaires out, and we maybe received 6 responses, and most of those responses were not full responses. The reasons for, we speculate a little bit in our report on the reasons for the lack of response. We don't necessarily believe that all agencies were trying to avoid responding to our questionnaire, but it did ask for quite a bit of data, and data that they may not have had on hand. response. But basically, this points to a fundamental problem, is that in order to make recommendations about how to do Ncmd responses better, we need to have good information about how they are used at the present. Now, the first three recommendations that we offered address this in part, but we think that another agency with a professional staff and the relevant access, including security clearances, needs to investigate further how this works. We're asking that the investigation attempt to answer the following questions. What practices are currently in place across government for the use of neither confirm nor deny requests? How has the use of these responses expanded over time? And if so, are there any discernible causes for such expansion? I just want to note here that the expansion of the use of neither confirm nor deny responses doesn't necessarily indicate that there's a problem, but it might. And so we would like the investigation to look into this further. What are the appropriate reporting practices regarding the use of these procedures? What categories should agencies use when reporting Ncmd responses? What data would agencies themselves find useful to collect? And we offer this suggestion in particular because we believe that an investigation such as this could help agencies to better understand themselves how they track, or better understand themselves how they use these responses. Under what circumstances do agencies issue Ncmd responses without conducting an initial search for records? Under what circumstances do agencies conduct an initial search for records before issuing an Ncmd response? Based on the findings of this review, the investigatory body should make recommendations aimed at achieving the following goals: ensuring that neither confirm nor deny responses are being used in a manner consistent with the goals of the FOIA, implementing reporting requirements regarding the use of Ncmd responses, improving communication about Ncmd responses with the public, reducing the unnecessary and inappropriate use of the Ncmd responses, and ensuring that agencies only issue Ncmd responses when conducting an initial search for records when absolutely necessary. The recommendations should be addressed to both the Congress and the executive branch. So those are our recommendations. And at this time, we'd love to hear any feedback or questions from members of the committee. Thank you very much.
James, thank you very much. Great presentation. A lot to think about, and I'm going to turn it over to committee members to ask questions.
This is Bobby. First, I just want to say thanks so much, James and Kristen and Kel, for all the great work you did on this and for sharing the white paper. I just had 2 comments and then 1 question. So maybe I'll start with the comments and leave it at the questions. First, I want to say I do appreciate having more data on this topic, and that would be I can see that would be helpful. But I do want to push back just a little bit on agencies properly reporting on it with the current existing guidance. As you know, we have comprehensive guidance to agencies on these reporting requirements, and we do provide refresher training every year to the agencies that are managing this data and reporting to us. And also agencies validate, and we validate the data to make sure that is as accurate as possible. And in specific to this, for example, if we have seen, in the other disposition category, an agency put in a Glomark response, we would go back to verify that it should be a full denial. So I wanted to push back a little bit on the data not being accurate, but that's separate, of course, from more data being helpful. Second, as far as the conducting of a search, there are instances where the agency will know without having to conduct the search that the existence of a fact is exempt. And that's where really Glomark comes. So I don't necessarily believe that not conducting a search when the agency knows that the information is exempt, the existence of it is necessarily wrong, or is wrong, I say that. And then finally, my question, as far as the first recommendation, I kind of hinted at this, I think, when a couple days ago. I'm interested to see, were there examples that you saw, or are there examples in where the agency is describing their withholding as a Glomark without explaining that they're neither confirming or denying the existence based off an exemption? Of course, I understand that we don't want to use that type of nomenclature necessarily when responding to the public or in public to requesters who are not familiar. But I'm not sure that the internal use of it by government agencies that have been using it for years has a significant impact. So I just wanted where your thoughts were more on that, if you don't mind.
Mm-hmm. Okay, thank you so much, Bobby. This is James Stoker again. If the other committee members don't mind, I'll respond to at least some of that. First off, let me say thank you for your comment on reporting practices. It's great to hear that OIB is monitoring this carefully and verifying that government agencies are reporting this as reporting these as full denials, which is what is recommended and I think required, as you said, by the DOJ. It's good to know that it's being validated. I think that this concern was in part sparked by the lack of responses to our questionnaire, but it also raises the question of how other types of GLOMARs are reported. For instance, partial GLOMARs, right? Are those reported as full denials if something is partially GLOMAR'd, then responses are but there is some records are released even though it's partially GLOMAR'd. I think that there are big questions about how this works and how it's reported, and that's why we're asking for additional data. So the line between asking for additional data and current practices can get a little blurry. Our goal with this recommendation, though, is ultimately not to criticize, but to think about how this could be conducted better. And so I think that we're on the same page there. On conducting a search, is not conducting a search necessarily wrong? Well, no, I don't think the subcommittee is suggesting that not conducting a search is wrong in all circumstances. However, there is an impression, and this is one of those impressions that maybe the requester community has, that's difficult to validate empirically because we don't necessarily have data about this. But the impression is that it's much easier for a government agency to use a neither confirm nor deny response than to actually go through the effort of conducting a search. So if that may be an incentive to use this response. And we're not able to substantiate that in all cases, although I think that some members of the subcommittee might have personal experiences that they could share. I'm looking at one colleague in particular right now that suggests that this might be the case. But nonetheless, I think that it is important to search a case. So there are reasons to conduct a search that are beneficial, and I might let my colleague talk about that here in just a minute. And then finally, on the first recommendation, you asked if there are specific examples of use of the term GLOMAR in communications from government. No, I don't think so. So if you look at response letters, for instance, I have not seen any that use the term GLOMAR, right? So it's true that there are not responses being sent directly to the public. However, agency websites do often mention the term GLOMAR. So for instance, the FOIA updates published by OIP, the OIP guidance on GLOMARization. Those are using the term GLOMAR, and those are documents that are intended, of course, for government use, but also for non-government use as well. So we believe that standardizing the use of this term would be ultimately useful. I will say that within the subcommittee, there were initially some questions about whether or not this recommendation would really make a large difference. And I would say that of the recommendations we're making, this may be the least essential one. But I do believe that it will make things, make it more useful. In part because it helps to demystify what's going on. I mean, one of the problems philosophically, at least from my perspective, is that we see the term like GLOMAR, and it just seems so extraordinary. It seems out of the ordinary. It seems like, there's just something happening that we're just unable to comprehend, and makes it, and for an average person not steeped in the case law, or it may be a deterrent to say further appealing something or revising your request and proceeding further. So using terminology that is more comprehensible is one step towards addressing that. I hope that responds to your comments.
And this is Kel. As the aforementioned colleague that he was referring to, one of the reasons that this is the search thing is an issue is that if you file enough requests with the agencies that tend to do Glomars, you start to notice a few things. And one of the things that we're hoping that this data gathering would quantify so that we could decide, is it just, all the agencies hate me, or is it that they, do this as a blanket policy? Are these instances where you'll have agencies that just reflexively Glomar anything about a particular topic? And for instance, that I'll give a hypothetical example. Let's say that OIP is one of these offices. And that if I file or I'll use FBI because OIP is too small. FBI is a big agency; they have a big FOIA office. This is the example I used when we were talking about it in Subcommittee. That if I file a FOIA request for all records about Alina Simo, they will Glomar it because whether or not they have FBI records on her is a privacy matter. That is what I would argue a legitimate argument. However, if I file a FOIA request for all records about Kristen Ellis, they will also Glomar it because giving the same exact form letter, saying because it's a third party, you need this, this, and this, and they won't even bother to check that she is a known FBI person who is publicly known to associate with the FBI. They will just go, oh, third party, Glomar. So we're trying to narrow down, say, if there are things, there are these places where, and it's not just privacy, it's intelligence, it's sources and methods, it's classification. If you do this enough, you see a lot of reflexive Glomarization of things that if they are pushed, like if you go to court, or if you appeal or something, they'll turn around and say, oh, sorry, here are some records we could give you. We didn't look for it because we Glomar'd. But they don't do that until you push them to that point. But we're having difficulty quantifying, is it just a couple agencies that do this, or is this a widespread thing? And how do we make it so that those agencies don't do that? If there are established guidelines that if it is a third-party request, you must search to see if there are any publicly acknowledgeable records about that person before you Glomar it. You must do sort of the minimum due diligence as a FOIA officer before you assert we can either confirm or deny.
Thanks, James. Okay, go ahead.
Bobby, I'm sorry. I don't know if you have a follow-up question. Alan has gracefully been waiting. He has his hand up, but I want to allow you to ask any follow-up questions first.
No follow-up questions. Just a couple of follow-up comments
Sure.
for consideration. I understand. I'm going to just say that again, reiterating that I think additional data, of course, is always good, and I'm not pushing back on that at all. And of course, in your example, Cal, I think you're talking about the application of the exemption not being accurate, not necessarily that a search had to be conducted to reach that conclusion. But pushing back a little bit, again, data can be helpful in maybe mystifying some of this. So I agree with that. And then going back to the first recommendation, I appreciate the context. I think side on not really necessarily agreeing with that recommendation because I don't think it's going to be impactful. But I do strongly agree that when even if the term Glomar is used, it should be used in connection with the neither confirm nor deny. So thank you so much.
Thanks, Bobby. Alan, you've been patiently waiting. Your turn.
Thank you, Alina. This is Alan Bletstein from America Rising Corporation. I want to quickly commend the subcommittee members for a very informative and well-researched report. Just a few quick comments. I think I agree with Bobby about recommendation 1 and the use of the term Glomar response. Every practice area has its nomenclature, and I'm not sure that Glomar is really that more problematic than the use of the term Vaughan index. There aren't a lot of these expressions in FOIA, and this is a seminal case and a fun, entertaining background with Howard Hughes and a submarine, and I wouldn't want to. I'm not sure it's necessary to torpedo it, to use a bad pun. The public understands what Miranda rights are. Brady violations. I'd be sad to see this term phased out as long as, like Bobby mentioned, there's the appropriate context. Agencies and courts shouldn't assume that readers understand these expressions. And the government has no shortage of abbreviations and acronyms, and Ncmd doesn't exactly roll off the tongue. I understand that it's used in Great Britain and some other countries, but I don't think there's pressure. I don't think we should change our nomenclature we should celebrate our differences. The rest of the world refers to football. When we use soccer, they use the metric system, and we don't. I just don't see that this is terribly problematic. I wouldn't die on this hill. It wouldn't be the end of the world, but I'm not sure it'd be the end of the world if we dropped this recommendation either. Other than that, with respect to recommendation 2, 2A, Roman numeral 4 and 5, these seem to me, I'll defer to agency employees here, but agencies don't track this information for any other exemption, and I'm not sure it's what warrants special treatment for Glomar responses. I'll leave it at that. And lastly, maybe this is just a concern about phraseology, but I'm not sure agencies should be giving legal advice or strategic advice about how requesters can circumvent exemptions. Agencies should advise requesters that they can submit proof of death or a waiver, or if there's an exemption 6 or 7C Glomar, but in terms of giving strategic advice, I'm not sure that's the agency's role. I'll end there. Thank you.
So this is Kel. I'm gonna leave the last one alone because that's really wasn't my baby. James can talk more about the guidance, but to the idea of the 2A5 item that. And for those of you playing along at home who don't have the document, this is that the agencies should report the number of Glomar responses that have not been upheld by a court. And 2A4 is that have not been upheld on appeal. The reason that we put 5 in is it was originally a one-part thing that said, appeal or court. And we decided we needed to separate that out into 2, but the reason we were talking about court in general in the first place was, if there are 2 ways of looking at the current use of Glomar over the last 30 years. One is that it's just fine and it's just the right amount. The other is that it's being overused when it shouldn't be. And those of us who adhere to sort of the first camp of, it's fine, then yes, there's no real need for any more information about it being overturned because it's probably being overturned the exact right amount of time, as low as possible. those of us who believe that it is being overused, that it is being an issue that's being abused, and I will be here to criticize. I mean, James said we weren't here to criticize. I'm here to criticize. You know, if the Glomar system is being abused, and we or anybody else ultimately asks for some form of reform of it, which would be the next step if the data supports our reasoning, then one of the things that we will have to grapple with is, well, you say it's being abused, but the agency says it's not. And who are we, members of Congress, to sort of believe you over them? Whereas if we say it's being abused and it's being overturned a lot in court, then it's not just me, random person talking to Congress, versus Bobby Talabian. It's me and 5 district court judges against Bobby Talabian. And so, but on the other hand, if it turns out that it is not being reversed a lot in court, that could support the argument that it is being used the right amount. It could also signal, based on the other data, the possible outcome that, well, even if an objective viewpoint looking at this, based on all the data we collected, would say it's being overused, it's still not being overturned in court, well, then that might mean that the court review needs to change. That needs the level of deference or the burden of proof or something like that needs to change if the court results aren't the same as, you know, our results or Congress's results or whoever studies this data. So either way, it's a point of data. Nobody asks for information about how many times B3 has been overturned in litigation, or B5 has been overturned in litigation, or B7 has been overturned in litigation, because those aren't A, super hotly contested items all the time, and B, an instance where there is even less information than usual for people to judge on. Glomar, when you get to court, many Glomar declarations say, we found that the fact of this, and I'll use a specific example, a CIA declaration that I thought was remarkable, and the court disagreed with me, where the CIA declaration said, the fact of the existence or non-existence of responsive records is classified because it could reveal intelligent sources and methods. Intelligent sources and methods are such things as A, B, C, and D. And that was it. It did not say that this piece of information was A, B, C, or D. It just said, intelligent sources and methods are important. Here's 4 clear examples of low-hanging fruit that everybody would agree with. Now give us Glomar. And the court said, okay, I trust you. That is problematic in some of these cases, especially when we later get more information that said that that wasn't exactly an accurate representation. So, and I wouldn't say that if we were investigating B5, we wouldn't say that they should probably do this as well. The reason we're asking for it for Glomar is because we happen to be looking at Glomar right now. You know, we might look at something else. There may be a trend, and you know, now they have to report losses in litigation on all exemptions down the road. I don't know. I'm not sure that would be a good idea. I'm not sure it would be a bad idea. But we're talking about Glomar today, and that's the one that is in desperate need of more information about how it's being implemented both by the agencies and how it's being reviewed by the courts. That's my 2 cents.
Hi, this is Bobby again, and I want to thank Alan for his comments, Kel for your response. One thing, as far as, and I wasn't looking into detail as far as line level of data that we would maybe want to collect on this topic. I'm keeping an open mind, but as far as any data on litigation, that we already have. That's already freely available. You can pull that up. OIP reviews every case decision that's issued. We provide summaries of those decisions by topic, Glomar being one of them, and they're all tagged. So you can search and pull up all the cases where Glomar is an issue, see where the courts landed on that. So that's not data that's hidden to us. And you can use that for any exemption, not just Glomar upholding or not upholding of Glomars.
Jason had his hand up. Had a question.
Yes, Jason Dart, History Associates Incorporated. So very interesting. Thanks, James, Kristen, Cal. Very interesting draft recommendation. I guess just one kind of historical comment, one futurist comment, and then I guess a question. James, you had mentioned that that Glomar is a submarine. It's actually the vessel, the exploration vessel, and it's huge, obviously. And the submarine was a Soviet submarine, K-129. But I think that's important because we talk about language and the importance of how you describe things. And I would say that, at least for me, who's not who's not as up to date or up to speed on the actual legal issue, I think that the terminology, if you get a response as a requester and the response is neither confirm nor deny, that describes what's happened to you as a customer, as someone that's put in a request and tried to get a response. So I think, for me, that's the language that should be used. And again, that's as a commercial requester. I say that as a commercial requester, someone who, hasn't litigated. And then my second, the futurist question is, Bobby, you mentioned that, it's important, additional data is important. And I guess, what's your recommendation, James, Cal, Kristen, to how to get better information from the agencies? I assume when you sent your questionnaire, it was prefaced with the fact that, you're a subcommittee, you're working with OGIS, and I would say that, I think in your draft, you said you sent the questionnaire to 23 people and only 6 responses. I mean, as again, I would say that's kind of disappointing of those that work inside the federal government to not actually fill out the questionnaire and help in the process. So what would the suggestion be to a future subcommittee or a future FOIA committee, advisory committee, on how to get better responses to help you actually build a better recommendation?
Sorry, this is James. I can respond to that unless somebody else wants to take that. And if I may, I'll just respond to sort of several comments at once. I'll start with Jason maybe, and then I'll go back to Alan, who made some very good comments that deserve a response. First, I'm a historian too, and so I thank you for the corrective on that. It was actually the ship or the drilling platform that was looking for the submarine and not the submarine itself. So that's certainly true. But I also agree with your comment that it should be described as it is to the extent possible, and it is a neither confirm nor deny response, and that's why I prefer the topic. That's why I prefer that term. Alan expressed, an attachment to the name, the Glomar, and the story, and I do understand that. As a historian, I love stories, but I think there's a kind of a dividing line here on how people feel that I've observed when I've discussed the possibility of recommending a name change. It seems that attorneys and litigators are particularly attached to this comment, in part because it's so often used in court cases, whereas others seem less attached to the cases, or less attached to the name, maybe because they're not dealing with the court documents around that. And so that could partially explain why some people are maybe prefer the name Glomar. I just think it's easier to use a simpler term where possible. And yes, you're absolutely right. We use terms like Miranda rights and others that are terms of art. But people have a good understanding of what Miranda rights are. I think if you look at pop culture, Miranda rights are everywhere. We have a good understanding of what they are. And while Glomar occasionally gets attention, I don't think that it has that same level of recognition as some of these other concepts. So I still think that there's a good argument for recommending that one particular term be used, even if I may not be able to convince other people of that. Jason also noted that it was disappointing that only 6 agencies responded. We were disappointed too. We do also recognize that we were asking for a lot of data, and we were asking for it on a short turnaround period. But you know, in a number of cases we didn't even get a response to it. And in one case, one agency actually treated it as a FOIA request, and basically just assumed we were making a FOIA request and didn't even sort of pay attention to the text that said who we are and what we were asking for. So yes, I agree that was disappointing. In recommendation number 4, we ask another government body to take over the investigation, whether one under the National Archives or outside of the National Archives. And we note particularly that we think it should be made mandatory. And I think that's the only way that you're going to get some agencies to respond to this, is if you make it mandatory. And that's why, to really get answers from, say, some agencies in the intelligence sector, you may have to have the Intelligence Community Inspector General doing the investigation, because a request from them cannot be ignored, or at least cannot be ignored as easily. So I hope that addresses that. Finally, just briefly, Alan noted that we may or may not want to be asking agencies to specify how to get around get around FOIA exemptions. I do understand that. I don't think that that's what we're asking for. I don't think we're asking agencies to help others to violate these exceptions. We're asking them to help people to get access to documents that they should have a legal right to. Right. So, for instance, if documents are unclassified, right, there have to be ways of accessing them to make sure that they get done. I'm reminded of there's an article on the CNN website recently about a request regarding James Brown to the CIA. Basically, some CNN journalists seem to have filed a FOIA request with the CIA for any documents about whether or not the agency conducted any surveillance on James Brown overseas, the singer. And they Glomarked it, basically, while also saying that they had conducted a search of unclassified records, and they didn't find anything in their unclassified records, right? It was good that they did this search of their unclassified records, even while they felt that they needed to Glomar records about this individual in particular. Now, whether or not they should be releasing records or doing more of a search, or what kind of search of their classified records they did, that's sort of another question. But the fact that they conducted a search of these unclassified records is something good and something to be encouraged. I don't think that they treat all requests for records about individuals in that manner, unfortunately. And so if there's a way that that a requester can phrase their request to get a response that involves a search for records that may possibly be released, agencies should be advising about how to do that. And even more so in cases that don't affect national security, so for privacy, for instance, or law enforcement investigations, things like that. We're not asking agencies to help anyone to violate the exemption. We're asking them to help get access to records that requesters have a right to.
And this is Kel. I can sort of back up on some of that. So it's important here that we note that even though we are the classification subcommittee, our recommendations are not for just Glomar for classification matters. We're talking about Glomar usage, period. And while everyone knows that Glomar is used for classified material and Glomar is used for privacy material, and it's also used for other things, but the discrepancy often comes down to, for instance, how much information is given about how to satisfy the agency's need to not assert a Glomar for different agents or for different exemptions. For instance, the FBI, as much as I bash on them a lot, they're pretty good about saying up front, we want you to give proof of death, privacy waiver, or overriding public interest when you submit a third-party request for records about somebody. That's a B6, B7C thing. They're pretty good about giving that guidance. Other agencies are not always so good, and even FBI is not always so good when it comes to other exemptions. Now, use sort of what terminology you would use. For the longest time, and it still goes on at some agencies, but many intelligence agencies that will reflexively Glomar a lot of things. The dirty little secret is that they will Glomar something automatically if you ask for records about a person. But they will not, because the subjects of who we surveil and who we are interested in, if 4.7 billion people filed FOIA requests, they'd be able to build a heat map of who we look at and what our intelligence priorities are. That's the argument that goes into the NSA, CIA, etc. But if you ask for records about an event that that person was at the middle of, they won't Glomar it often. And that you can even, this is something that they don't, I call it the dirty little secret. It's a poorly kept secret. I mean, they're pretty open about it in many cases. And I've been, in fact, told by FOIA officers, just if you want to, one of my cases, I was going for records about the former head of the German, East German state police and secret police. And the agency basically told me, yeah, if you ask for records about this guy, we're going to Glomar it, because we will always Glomar records for a guy. But if you ask for records about the fall of the Stasi on this day that he was in the middle of, then we'll give you records about that, or at least we'll conduct a search. So guidance like that, if an agency has a policy that we automatically reject things because of one reason or another, then their website should say, we have a policy of this, and here's the information you would need to give us in order for us to not trigger that policy.
Tom Sussman has a question or a comment.
First, I noticed in the chat early on, one of the attendees, Freddie Martinez, raised a question about whether there's any possibility of splitting out whether a Glomar denial is based on B1, B3, B6, B7, in terms of, telling the requester, because frankly, my personal experience is you don't win national security cases. And that sort of then goes to the litigation issue, which Kel may have an insight on, which is many of the cases where the court has challenged a Glomar response result in zero documents anyway. And my impression is that most of that's in the national security area, maybe some in law enforcement, but probably not much in privacy. But that was something that I wanted to sort of get the committee, subcommittee members' sense of.
I'll bite. I don't understand what the question is, or if there was a question.
Well, I think the first question was, does it make sense to require disclosure by the agency when it denies based on a Glomar response exactly what exemption it would be relying on underneath, so that it gives you some idea of whether it's worth challenging?
I think, this is Kristen at the FBI. I think it is already required, at least in litigation, you have to tie a Glomar to an exemption. It might be that exemptions are grouped together. For instance, most agencies that assert a national security Glomar usually will cite B1, B3 if they're protecting intelligence sources and methods information, since both exemptions cover that. Same thing with a law enforcement agency protecting privacy information. They're usually going to cite 6 and 7C. But Glomar doesn't exist on its own. Glomar is an assertion of an exemption. It's just a unique way of asserting an exemption. So if agencies are not doing that already, they absolutely should be. But there shouldn't be a circumstance under which it's just cited without tying it to an exemption or more than one exemption.
Absolutely, and I just wanted that requirement is no different administratively than it is in litigation.
Michael Morrissey and Patricia Weth both have their hands up. Michael, do you want to go first?
Sure. Thank you so much. Thank you. This is Michael Morrissey on the FOIA Advisory Committee. I work at Muckrock. I think I think this is a really helpful area to kind of dig into, and I really appreciate the working group's efforts in this area. I do think that there's just immense confusion and uncertainty around Glomark, even by really experienced requesters. And I think, as kind of mentioned, the agencies have actually seen this blow up in their face when there is no actual document properly underlined there, and somebody misinterprets it. And so I think improving that language is, I think, a really big opportunity, both to make requesters' lives easier, but also to kind of help agencies actually do their job with minimal confusion among the public. And that's why one of my favorite pieces of this recommendation was just improving sort of the language and pointing to the CIA's documentation around how they use Glomar. I would love to see more agencies do that, not just on their reading rooms, which I think a very small number of requesters actually use, but starting to put more of that language in the response letter as well. And while I agree with Alan's point about the beauty of the Glomar moniker, and I'd hate to see that completely go away because I think it is an illustrative story. One thing I did find is that agencies don't necessarily just say, oh, this is a Glomar rejection, but they will say, instead of neither confirm nor deny, they'll say any responsive documents would be exempt, so we're not going to search, or they'll use different phrases for that. And I do think that has an impact both on being able to research these issues as well as requesters being able to find resources. If you can Google neither confirm nor deny, you'll get some really helpful information. If you Google because any non-public records responsive to your request would be categorically exempt from disclosure, you're probably going to get fewer resources. And so I think pushing agencies to standardize how they address these exemptions, I think that would be worthwhile. And I think that is something that would make it easier to kind of understand this issue going forward and also help requesters in the short term. And then finally, and this might be, I'm on the process subcommittee, so this might be just our kind of process perspective on things, but I think we do ask agencies to do just this enormous number of reports, and I think that data is really helpful. I wonder if this is an opportunity to kind of look at, can we push agencies, and particularly agencies' FOIA processing systems to release more bulk data so that rather than having to do all of these specialized reports, could we get more granular data about the number of exemptions that are applied on individual requests so that we can start seeing sort of, you know, maybe it's today it's Glomar, maybe tomorrow it's another issue, how often different agencies apply these and kind of do more advanced analysis rather than just giving them another sort of aggregate report to develop and fill out going forward. But I do like the gist of these recommendations. I do really like standardizing some of the language and particularly giving the agencies backing and support and a little direction in terms of putting together more readable plain language responses so that they can interpret what a Glomar is out of the gate. So thank you again. And I think this was a really, really helpful investigation. And I really do hope we get some of these recommendations passed into our final report and recommendation to the, yeah.
Thanks, Michael. Cal has been waving at me. I think he wants to respond to Michael.
I just one particular point, something that you raised that we didn't really discuss that much, and it might be worth a future discussion. There is, and this is the lawyer in me talking, there is a difference, a distinction between a categorical exemption and a Glomar response. And while I do definitely agree, now that you mention it, that this distinction needs to be made clear in an administrative letter, in a response letter, that is not what we're talking about here. And so in a categorical exemption, they're saying we're not going to search because we would withhold everything. In a Glomar, they say even if we have nothing, telling you we have nothing would would reveal that we were not watching Michael Morrissey on the day that he committed this heinous crime. And so that would reveal to him that he has been undetected and he can escape crime, can continue to escape crime. So it is to a lay person, to sort of a normal, non-insane legal person, they are very closely related, and they may even seem indistinguishable. But from a legal standpoint, they are different. But I agree that they should definitely make clear that we are not issuing a Glomark response. We're just saying this is a categorical exemption. But that's sort of beyond the scope of this recommendation.
Okay, thanks, Cal. Patricia, you've been waiting so patiently.
Yes, thank you, Alina. Patricia Weth with EPA. First of all, I just want to thank this subcommittee, James, Kirsten, and Cal. This is, I can tell, a lot of thought, a lot of time and energy went into it, and it's really well thought out. I do have to say, when Alan was talking, I felt like he was reading my mind, because I echo all of his comments. For number one recommendation, I don't see this as being that big of a problem. If it were the type of thing where agencies were in their response letters saying, you know, I Glomar this FOIA request, that would be one thing. But agencies, well, in my experience, no agency does that. They usually say they neither confirm or deny, and will cite to the Glomark case. So I don't see that as being a problem. But one suggestion I have is you might want to take this number one and maybe merge it with your third recommendation. Because I think that's a good recommendation, but it may get passed if you revise it. And this is where you suggest that federal government agencies on their websites explain what a Glomar response is. And I do think that's a really good idea. You know, most agencies have a FOIA reference guide on their website, and they explain the exemptions. I think it's a good idea to also explain what a Glomar response is. You can either confirm or deny, explain maybe a little bit about the Glomar case. But I think the way number three is written now, I would have concern about it getting past this subcommittee, because you know, you might want to strike the language and, where possible, recommendations on how to avoid such a request, such a response. You know, I think, anyway, these are just my suggestions. For number two, where you're asking for information to be collected regarding neither confirmed or deny responses, I echo Alan's comments regarding Roman numeral 4 and 5. Regarding Roman numeral 2 and 3, as somebody who's responsible for doing the annual report at EPA and also formally at the National Labor Relations Board, I'm very familiar with our annual reports. And spend a good chunk of September, October, and November going over them. We don't do this for the exemptions. So I'm not sure how collecting this information, Roman numeral 2 and 3, for neither confirm nor deny would be helpful. And lastly, the fourth recommendation that you have, I love getting guidance from OGIS and DOJ on all things FOIA related. So I think that's always helpful. And That is my 2 cents. So thank you for the time.
Thanks very much for that, Patricia. I wonder if somebody else could respond. I think I've been talking a lot this particular meeting. Krista, would you like to respond? Well, I guess I could. So, first off, Patricia, thanks very much for those comments. I appreciate the attention you paid to the detail in the report. On number one, I see how having an explanation on the agency website could be helpful, but the response I might give to that, another way of approaching this, is that if agencies are already doing this, if they're already using neither confirm nor deny, then it won't be much of an ask to ask them to use this term consistently, right? So if there just won't be much to do, and that will really simplify things. And then it also has the advantage, as Michael mentioned, of standardizing language across government. And I think that's the suggestion that Michael made is actually, it's a good one, and it's actually one that we could maybe emphasize more in this recommendation if we were to revise it. I'm not sure if we're going to take a vote or not today, but we could certainly focus it a little bit more on this idea of standardizing the way that we talk about this. So I do appreciate your comment, but you know, if it's not much of an ask, then it doesn't seem like something that would raise a lot of objections. On number two, I do think it would be useful to track, you know, this more specific data about neither confirm nor deny responses. So were they in whole or were they in part, right? Because like we said, there are many times this is used in conjunction with other types of responses. So it may be a full denial and then a partial Glomar, or it may be, you know, a release of some documents and then a partial Glomar as well. And if we code them all the same way, whether or not they're partial or full, we won't really have a good understanding of what is happening. Now, we do recognize in this report that this is an ask for agencies, and we recognize in particular that it will require things like updating software systems, right? So you have your FOIA software, and you know, I don't know exactly how it works, but you know, I'm sure that somewhere there's a box to tick that says, you know, is this a full denial? Is it a rejection? Is it and you know, somewhere in there you'll probably have to add you know, the Glomar, and maybe more than one option will have to be chosen. And this may differ from agency to agency. So we don't want to be too specific about how this will work on an information technology level. But if we don't track this more granular data, we won't actually have a good sense of what's happening. So thanks very much.
This is Kel. The one thing I will add is, and it's not necessarily about this recommendation, but about sort of all recommendations. But you know, it applies to this recommendation number 4 and 5. Items 4 and 5. Patricia's argument, part of it is, well, this isn't something we track, and I'm going to vastly oversimplify it. So obviously, no offense to Patricia, who I work with very closely in the legislation committee, but if we tracked it, we wouldn't need a recommendation. And my personal view of the role of this committee in this recommendation and in all the other recommendations is to identify things that need to change and recommend that they change. The fact that you don't track this is sort of the thing we're identifying. We're saying we should track this. That these are things that should be tracked. These are things that should be reported. And to James's point, yes, this is going to impose a new burden on an agency, but the question is it an inappropriate burden? And I think our position, at least mine and James's position, and probably Kristen's as well, but I can't speak for her, is that it's not an inappropriate burden because of the need. You know, every agency burden has to be counterbalanced by the need for the burden. And in this case, we think that the need to be more clear on how Glomar is used and how often it is upheld outweighs the burden of now you have to report on something you didn't have to report on before. But that's just my thoughts on that.
Okay, I'm watching our time. It's 11:30 already, so I'm very mindful of that. And it's been a really great discussion. I really don't mean to cut anyone off. I think Bobby wanted to just respond to something that Michael had said earlier. So, Bobby, do you want to just make a quick comment?
Really quick. Just to point out to Michael's comment, I appreciate the comments, Michael, that in addition to the annual report, agencies post the raw data. So that's, I think, somewhat of the bulk data you're referencing, line by line, every element of what goes to the report by request. Of course, that wouldn't include Glomark because that's not being captured in the annual report separately. And then just very quickly, I will say I did appreciate in the white paper that it was this reporting, additional potential reporting was not specifically tied necessarily at first or at all to the annual report. And I think I'm keeping an open mind. Obviously, this recommendation is aimed at OIP. That in a lot of ways, what we do, the CFO report would maybe be a better vehicle to better understand the need, justify it, and burden as well as reporting as well. So I wanted to let you know that was a thought of mine, and I appreciate that you had approached that and appreciated the burden on agencies when coming up with this recommendation. Thank you.
Okay, thanks. I'm going to ask the subcommittee co-chairs. I know we've had a lot of discussion today. James and Kristen, are you ready to move forward with a vote today, or do you want to absorb everything that's gone on today, review the transcript after the fact, and represent at the March 2022 meeting for a vote? What would you like to do?
So this is James. I am open to reviewing the many comments that committee members had. We didn't hope for a vote today, but there have been so many comments that I think we need to at least consider them in a subcommittee meeting before we have a vote.
Okay, I appreciate that. Thank you. All right, well, I'm going to ask the technology subcommittee co-chairs, Allison and Jason, how much time do you all feel like you need to present? Trying to get a gauge on whether we should take a break now, or maybe we could go another 15 minutes and take a break at around 11:45.
I think 10-15 minutes should be plenty. Jason, what do you think?
Yeah, I think so as well. We can keep it short.
Okay, great. And I don't need to rush you, so if you need more time after the break, we can certainly do that too. Michelle, can you advance to the next slide, please? And another slide. And another slide. Okay, here we are. All right, Jason and Allison, you're on. I don't know who's presenting. Go ahead.
Yeah, I'm gonna present Jason Gart History Associates Incorporated. I'm gonna present this morning, and Alice and I worked closely on just on our presentation. So the technology subcommittee has continued to meet every 2 weeks since our last meeting in September. We've been working on 2 recommendations for the full committee. The first focuses on enhancements that agencies can make to their FOIA websites to facilitate a better experience for the requester community. This builds upon a recommendation from the prior Terms Advisory Committee, specifically recommendation 2020-01, where OGIS will assess information about FOIA filing process available on agency websites with the goal of informing further OIP guidance on how agencies can improve the online descriptions of the process. As we discussed in September, we believe FOIA websites should include some baseline features, a listings of the type of records maintained by the agency, but then also a listing of the type of records that they do not maintain. We think they should be linked to, there should be links to agency record schedules and any applicable capstone policies. Also some guidance or best practices for writing a FOIA request for the requester, for those that might not be experienced doing so, and possibly even with agency-specific examples. And then some guidance or a description of the types of requests that would be considered overly burdensome by the agency or not sufficiently specific. Again, to help the requester submit a better request. We're certainly trying to balance these suggestions with the reality that each agency has different needs, and that we don't want to prevent agencies from going above and beyond our own recommendations if they're too restrictive. So one issue that's come up in the last 3 months is that our recommendations have been overtaken by recent events, and you can, overtaken or benefited, I guess, depending on how you see it, with the announcement that EPA will be retiring the FOIA Online platform at the end of fiscal year 2023. As a result, 20 agencies will be looking to transition to new systems. And we feel, the subcommittee feels, that we're in a unique position to provide recommendations that reflect both the interests of the community and the federal agencies in perhaps, picking that new system. And we will be working on some suggestions to agencies, or some guidance that we will then circulate to the broader advisory committee on considerations of what type of new systems, what type of basic functionality considerations, and what type of wish list items should be considered. And then our thought is that this list of recommendations could then be used by the commercial developers, those in the commercial software field, to help create or modify existing systems, or even develop new ones to meet not just the needs of today, but the needs of the future. And ultimately here, and I think, something we talked about before, is that the goal here is that agencies should really keep the user experience, the requester experience, the customer experience forefront in their websites. That we want it to be easy to use, and we want there to be information on there to help streamline the process, to help work with the requesters to get materials released efficiently. And then the second recommendation that we are focusing on is best practices for the release of records in standardized ways. Again, this is something we discussed last time. Again, the subcommittee is investigating, how whether records should be released in native format. But we also understand that the need of classified national security records may require special protocols. And some of the issues that we've discussed internally, and we will certainly be raising to you all, is that with dealing with classified materials, agencies prefer flattened PDFs when releasing, so nothing in native format. Most agencies release emails, PowerPoints, and PDFs, although some do Excel spreadsheets just as is. Should emails be released or should be provided in PDF or just as plain text files? We think this is an important issue for both technology subcommittee and then the broader advisory committee, because it hasn't been covered by prior committees. We predict that this is going to be a bigger issue, especially as FOIA agencies, especially as NARA directed federal agencies to transition to a fully electronic environment in December 31st, 2022. And again, this picks up on the previous conversation that Allison and I raised about metadata and how critical it is, and the feeling that it should not be stripped away unless absolutely necessary when materials are released. And we also look to our state level document releases for those that are in the FOIA or open records that they do release metadata. So that's where things stand for the subcommittee. I asked right now Allison, AJ, Kristen, Roger, did I miss anything? Is there anything else we want to raise or flag? David. And then I open it for other questions from everyone. Thank you.
Jason. I don't know if anyone else had a interference. I didn't hear everything Jason said. Did anyone else have trouble hearing Jason? Yes, I'm seeing some nods. Thank you.
I can summarize what Jason had said. So a lot of our original conversations within the subcommittee had been about what recommendations we would make to agencies to improve websites to best serve the requester community, and also to help agencies if requesters are told, okay, these are the types of records we're keeping, for how long, these are the types of records that this agency does not keep, therefore minimizing unnecessary requests, that type of thing. But then with the announcement by EPA that they're sunsetting the FOIA online system at the end of fiscal year 2023, I think it is, that presented an opportunity for the technology subcommittee to work with the requester community and the agencies to come up with suggested options for bare minimums for agencies to consider, as well as some wish list items, and that could also be used by the software developers to meet those needs. And then we've also still going back with one of the earlier recommendations to look at best practices for the way to possibly standardize the way documents are released, but also acknowledging that certain agencies have concerns about accidentally releasing information that might be embedded, that might not automatically come out if we were to release something natively. And then we were opening it up to the floor for other committee members if they had anything to add, or the subcommittee members if we missed anything, or committee conversation in general.
Okay, great. Thanks. Any subcommittee members want to add anything to the technology subcommittee's report? AJ's shaking his head no. Okay. Anyone else have any questions for the technology subcommittee before we go to break? Going once, going twice. Well, we certainly look forward to your best practices recommendations. Perhaps you'll be ready to roll that out for prime time in March. So we'll see how that goes. Okay, so with that, I think we're ready to take a 15-minute break. If we could try to keep it to 10, that would be really great, so we could try to get back on track. But maybe as a compromise, we'll say 12 minutes, between 10 and 12 minutes. So let's take a break right now, and we'll be back soon. All right, thanks, everyone.
and gentlemen, welcome back. We will be proceeding with the webinar.
All right, hello,
Don't
everyone.
forget to unmute yourself, everyone.
Thanks, Michelle. Sorry, I didn't mean to speak over you. Welcome back, everyone. Hopefully we have almost everyone back on camera, the committee members. We're going to switch things up a little bit from our agenda. I did advertise at the beginning of our meeting that we're going to keep things a little flexible. And I have asked the process subcommittee to present next. And legislation will go last, but definitely not least. So with that, I am going to turn it over to subcommittee co-chairs Michael Morrissey and Alexis Graves.
All right, perfect. Good morning, everyone. I am Alexis Graves, the Director for the Office of Information Affairs at USDA. I am the co-chair of the Process Subcommittee, along with my esteemed colleague, Michael Morrissey, and also a member of the First Person FOIA Working Group. I am just so very excited to share with you guys the work, the recommendations crafted by our First Person FOIA Working Group, which was led by our colleague, Roger. Other working members included Tuan, who so graciously compiled, the team's thoughts and notes and pinned the recommendations circulated. And finally, but certainly not least, we cannot forget our resident FOIA guru, Tom Sussman. I want to start first with acknowledging and thanking all of the agencies and the advocacy groups that really provided their insight about their handling of and their challenges with first-person access requests. We very much appreciate their time, attention to this issue, and as always, their feedback. We very much look forward to continued work with all of these groups. I also want to thank former advisory committee member, professor and author, Margaret Kwoka, whose work really served as the framework for the recommendations being presented today. I think most of us at this point in the committee are familiar with Margaret's work and the phenomenal job she's really done with highlighting how FOIA, as she says, it can suffer under the weight of its unintended uses. And so as an example of this, as many of you know, there's no discovery process, right, in the immigration court system as there is with the federal district court system. So a lot of times immigration lawyers use FOIA to retrieve those records needed to defend their clients. And so with that, it should be no surprise that our recommendation for discussion today builds upon that one previously set by the 2018 to 2020 term. And in that, just so you guys have a little bit of context, that one recommended that OGIS and the Department of Justice Office of Information Policy identify those records frequently requested under the FOIA and or Privacy Acts by or on behalf of individuals seeking access records about themselves for the purpose of establishing alternative processes for access. We really saw this initial recommendation really advancing or achieving really two important objectives. First and foremost, we thought that it would ensure the timely processing of records that involve, one's life and liberty as well as their property interests. But secondly, it could also help aid some of our agencies in freeing up some very, very limited resources as well. Our working group saw this recommendation really as an excellent start, really kind of that springboard to address the access issue. But we did also feel that it looked at it from the 50,000-foot view, right? So this term, we wanted to give this issue a little bit more life. We wanted to do a bit of a deeper dive and put forward some specific recommendations. And so as a starting point, just so you guys have a little bit of background, a little bit of context, we surveyed a few of the agencies identified by Professor Kwoka as really having large number of these first-person FOIA requests, as well as those requesters who, routinely conduct business with those agencies. And so this included the Internal Revenue Service, the Social Security Administration, entities within the Department of Homeland Security, specifically the United States Citizenship. I want to make sure I get the acronym correct, and they go by the acronym EOR. We were very, very pleased to learn that some of these agencies have already taken significant steps to kind of provide alternatives to filing FOIA requests to facilitate prompt access to some of these more frequently requested first-person records. And just so you guys have some examples of that, The IRS, we learned, has created this tax transcript, which is essentially, this summary document of tax information relating to a taxpayer's filings. And so this was a huge time and cost savings to IRS's FOIA program, as they no longer had to search for multiple records across multiple repositories to respond to these requests. Essentially, this singular report, encapsulated virtually everything and is now also conveniently available to the public via a self-service online account. Another really great example was from our own committee member, Linda Fry, from the Social Security Administration. Linda had shared with us that SSA receives a large number of access requests from folks seeking their applications, for Social Security cards, claims files, genealogical information. And so a lot of these requests are flagged upon receipt, and then they're sent to this cadre or a special team of agency workers that aids the SSA disclosure team with processing on a part-time basis. This cadre is trained by skilled disclosure analysts, and their work is also reviewed by the trained analysts once it's completed. So just kudos to IRS and SSA for their proactive action in handling these first-person access requests. And so switching gears, in our review of our agencies, our team also found some opportunities for growth. And so, again, I want to thank both USCIS and also EOR for sharing insight on their processes for handling their first-person requests. And so within USCIS, the A files were identified as a record that should have some alternative access. And for those who may be unfamiliar with the A file, essentially it's a collection of records maintained on a person that documents the person's immigration history. They're usually created when an application or a petition for a long-term or permanent benefit is received, or when there is some type of enforcement action initiated. USCIS, they shared with us that they understand the importance of the timely processing of these A files, and they certainly understand that the delays really have in processing really have grave consequences. And so they advise that they have made significant progress on their backlog of these A files since the filing of a 2019 class action by several immigration advocacy groups. In this suit, there was an allegation of routine violations of the FOIA statutory timeline. In that case, the court opined that the failure to timely process really undermines the fairness of immigration proceedings, particularly for the vast number of non-citizens navigating the immigration system. And so the court did ultimately order an injunctive release against USCIS, permanently enjoining it, from failing to adhere to the FOIA statutory deadlines for adjudicating these A file requests. And so USCIS was required to submit recurring compliance reports to document their progress with the A file backlogs. I am pleased to report that in their most recent compliance report, USCIS advised that it had reduced its A file backlog from 21,987 down to 244. So that's really a huge victory for that team. I want to ensure that our colleagues and also my colleagues on this working group that USCIS continues down this path of success. We want them to win. So we did ask that they reconsider implementing an alternative to first-person access requests. Our thought was that while the class action addressed specific individuals with liberty interests, it will most likely end up delaying those records requests of broader public concern, for which the FOIA was intended. USCIS did advise that there would be challenges in identifying an alternative, specifically if not being processed by the FOIA team, then they couldn't come up with other viable option. And so again, we look forward to continued discussions with USCIS. We see them as valuable partners with respect to the crafting of these recommendations. Another agency that we had the pleasure of speaking with was EOR. Again, they receive about 48,000 to about 60,000 requests annually, and about approximately 95% of these requests seek records of proceedings. They're known as ROPs, of respondents before immigration judges. These ROPs really kind of include everything under the sun. Hearing notices, applications for relief, exhibits, motions, briefs, hearing tapes, and then, of course, orders and decisions of the judge. So just a lot of very, very valuable information in these ROPs. Traditionally, these ROPs were kind of, housed in paper and all across the country, which, as many of you guys know who are processing FOIA day in, day out, making retrieval quite a challenge. Our team was really, really pleased to hear that EOR, with some of its partners, were already well underway rolling out an electronic system known by the acronym of ECAS, and this system is set up to essentially access and manage and store and transfer ROPs electronically and permit self-service access to DHS and also representative of non-citizens in proceedings before EOR. ECAS will unfortunately not be made available to the 46% of respondents going pro se. These individuals will need to continue to submit FOIA requests through EOR. So again, just wanted to give you guys a little bit of context and a little bit of information about the work that we've been doing. Let's go ahead and dive into the recommendations. And so I think recommendation 1 is fairly straightforward, but I will go ahead and just read it. They are records relied on by an agency that affect eligibility for benefits or adversely affect an individual in proceedings should be made automatically available and not require first-person FOIA practice. And so I will just say with that, while many of these individuals at stake here may not have formal due process claims, to broader access right, forcing these individuals to resort to FOIA kind of really undermines due process in fair proceedings, as well as making accurate agency determinations. With respect to recommendation 2, record access should not discriminate against pro se parties. We certainly understand that it's not advantageous to push one in the direction of moving pro se. For anyone, lawyers included, it can be a challenge to really kind of navigate that legal system right, particularly when your first language may not be English. But the reality is, as I explained before, we have about 46% of folks, and for a whole host of reasons, going pro se. And so we need to come up with a solution to accommodate this larger class of respondents. Maybe some of them are thinking about seeking counsel, but maybe they need some underlying paperwork, before the attorney decides whether or not to take on their case. Again, we certainly don't want to compound this issue. And so that is kind of our rationale for recommendation number 2. Recommendation number 3, agencies should use technology to leverage their effort to make first-person agency requests more easily accessible outside of the FOIA. IRS and EOR, as I had just described, are both really great examples of how technology can really positively change the trajectory of a program. And so that for that reason, we applaud them both for making and supporting the investment and demonstrating to their colleagues and peers in their agencies and partnering agencies that, these types of initiatives really do have a huge return on investment. As we are all being directed to, move toward a completely digital infrastructure with the OMB and NARA mandate in 1921. We really want to urge agencies to think about how to really capitalize on technology to make the retrieval of records for this first-person agency records more accessible to all. Recommendation number 4, agencies that receive frequent first-person requests can benefit from identifying the most commonly requested records and developing procedures for processing such records to promote efficiency and good, customer service. With all of the agencies we discussed today, it's clear that they've all really assessed their queue to identify those frequently requested first-person requests. It's also really clear that they understand the correlation between expeditiously processing these requests and also customer satisfaction. I think, what is really inspiring, though, with the group surveys is that you can really come up with solutions and procedures to kind of effectuate change and better serve customers that aren't necessarily so crazy expensive, right? I think SSA was a perfect example of that. I just think that it requires all of us to kind of dig deep, be creative in our thinking, and again, go outside the box. With recommendation number 5, other agencies that receive frequent first-person requests should consider the costs and benefits of moving to proactive systems for disclosure, such as that modeled by other agencies such as the IRS and SSA. And so there were other agencies identified, Professor Cuoca, where first-person requesters routinely request records under the FOIA that do relate to eligibility for benefits. And so two of those were the Veterans Health Administration as well as the Federal Emergency Management Administration, FEMA. And so agencies like these really should consider doing some, cost-benefit analysis of moving toward an electronic system that would essentially allow for easier access to the records. So that is our recommendations. I want to make sure that I open it to my colleagues if they have any additional comments about these recommendations. And then I think we may have some specific comments, correct, Alina, about these from some of the agencies that we partnered with.
Yes.
Perfect.
James has his hand up, but he's the first person I see. And Bobby has his hand up too. James, go first. Bobby next.
Okay, thanks so much, Alexis, for this presentation and for all the other members of the subcommittee for their work on this report. It seems like an excellent report. You all have done extensive research, and it's nice to see a document that has so much work that's gone into that. Speaking from the perspective of the Subcommittee on Classification that just did a project on Glomark, I wish we had the kind of access that you all have seem to have gotten. I was one of the drafters of this recommendation, based, of course, on the work of Professor Cuoca, and I'm really thrilled to see you all taking it further, following up on it so quickly, and developing it in specific manners. I just had a couple of comments about the recommendations. I noticed the recommendations section is much shorter than the analysis, which is not necessarily a problem, and maybe you're still in the process of developing it. But I think that a couple of the recommendations could really benefit from a bit more detail, particularly recommendation number 2, where you talk about how record access should not discriminate against pro se parties. Most of the content about the recommendation itself seems to focus on, the practices of EOR. And while that's a good example, it might be good to be a bit more specific about how record access would not be discriminating against pro se parties. Is it, making online forms that are easy to deal with, that clearly outline the cost structure? Is it, what is it exactly? Is it having a presence outside of the agency beyond just like a website interface? In other words, how do agencies go about making it easier to people that are representing themselves and not relying on counsel, right? And I think a basic principle of freedom of information access should be that you should not have to have an attorney in order to get access to that information, right? So the more detail you can go into there, the more suggestions you can offer, the better. And then on recommendation number 4, the phrasing of the recommendation struck me as interesting. You say that agencies that receive first-person requests can benefit from identifying the most commonly requested records and developing processes for processing such records to promote efficiency and good customer service. So that struck me more as like a best practice than a recommendation. And while that's not necessarily a problem, I think if you're going to make a recommendation, it might need to be a bit stronger. So you might have to say agencies that receive first-person requests should benefit or should identify the most commonly requested records. This, of course, was the original recommendation from the 2018-2020 term itself, that they should identify those most common records and then create new means of for accessing them. So in a sense, it's either a best practice or it kind of repeats what the original recommendation was. So that one may need a bit more attention as well. But again, I really love the direction in which this is going, and congratulate you all on the great work. Thank you.
Thank you, James, and thank you for both of those recommendations. We will definitely keep those under consideration.
Great, thanks. Bobby, you had your hand up.
Thank you. Thank you, Alexis, for the wonderful presentation and all the work of the subcommittee. I really appreciate it. The one thing I want to note is there's no question that having this information timely provided, it's important information for, and it serves a really crucial purpose, and timely disclosure of that to the individual is something that we all want. But I think it would be beneficial to the recommendations in the white paper to address some of the challenges. And for some of these, no matter what, the records are going to require some level of review for sensitivities, whether that be FOIA professionals, or whether it be, whether we're saying we're taking out of FOIA and it's still going to be FOIA professionals. So there's resources, I'm sure there. And there's other challenges. I don't think the agencies are not wanting to reduce the burden, provide these timely and reduce the burden on themselves. So I think in order for the recommendations to be, helpful to the purpose it's trying to serve, I think the challenges should really be analyzed, addressed. And I really do appreciate the last recommendation as far as a cost-benefit analysis. I think that's really helpful because, of course, we want to provide this information in the least taxpayer expensive way, in the most efficient way. And I would agree with James that I did find this recommendation number 4 a little bit redundant to the prior recommendation that identified commonly requested records that would fulfill. Thank you again, and I hope that's helpful.
No, that's very helpful, and I think some of the agencies probably agree with you that we should talk a little bit more about the challenges, and so definitely, certainly, we will, reconvene and talk about this. I think that's an excellent point.
Alan Blutstein has his hand up. Or is that from earlier, Alan?
Yes, no, thank you, Alina. Alan Blutstein, America Rising Corporation. I join James and Bobby in commending the group for its work here, and the fact-finding is very impressive. A few comments on the recommendations as well. Recommendation 5 seems to be swallowed up by 1. I wonder if it's an alternative recommendation. If recommendation 1 passes, I don't know that 5 is necessary. If you're confining 5 to agencies that provide benefits to the public, because recommendation 1 appears to mandate agencies to make proactive disclosures as opposed to just doing a cost-benefit analysis. And more on recommendation 1, I think I'd be more comfortable if we were making recommendations to specific agencies, especially the ones you've discussed. This one is sweeping across the government. I don't know that, I'm not sure some of these terms are quite broad and vague. I don't know what is meant by a proceeding, administrative, civil, law enforcement. I don't know that the hundreds of agencies are even going to know that this applies to them. And benefits as well. I don't. All financial benefits. I just don't know what the scope of this is. It seems to go well beyond the few agencies that you've discussed. I'll leave it at that. Thank you.
Thank you, Alan. I do appreciate that. And any of the working group members, if you have any comments, please, about the specific recommendations or any of the wonderful comments we're receiving from our committee members.
So I see Patricia Weth had her hand up. Was that from earlier, Patricia, or is this a new hand up?
This is a new hand up.
Great.
Patricia Weth from EPA. Again, want to compliment the entire working group for all their work that they've done. This is something that is near and dear to my heart. I'm just going to make one suggestion that I've noticed, one thought could be, because in recommendation D that you have, you talk about processes, different processes for processing records. One thought I'm just going to share broadly is that a lot of agencies can release records in their proceedings if they were to change their regulations. I've seen a lot of agencies require first-party requesters to go through the FOIA process instead of being able to receive the records in the particular proceeding that they're in. So that's just a thought I thought to share with the working group. Thanks.
Thank you, Patricia.
All right. Any other committee members have any comments? Allison just raised her hand.
Yep. One thought is, has the subcommittee looked at the impact of the Cases Act, which requires agencies to have certain information requests be submitted electronically? I didn't see anything in the recommendations, but I'm not sure how much it would impact, but maybe something just to say to also further expedite this or facilitate it, that these requests should be done electronically and not mailing in a form. That's all.
No, I think that's really helpful, Allison. I know that there was a very small conversation about that, but I think we should definitely revisit that.
Great, thanks.
Okay, I see Michael Morrissey has his hand up. Michael, go ahead.
I was not involved in the specific drafting of these recommendations, and so I can't take any credit for the wonderful work that went in here. But I do want to say, in terms of the differences between draft recommendation 1 and 5, I think one of the things that I kind of see is that a lot of the problems with FOIA kind of start way before the FOIA offices. And I think one of the hopes that I had, and one of the reasons I was excited about that recommendation, is forcing agencies to sort of stay, oh, our FOIA budget's huge, let's like kind of squeeze that. But then also look at, oh, you could spend a lot less money on this if you actually build out the systems to allow this proactive disclosure. So I think both pushing on those rights and then pushing on some mechanisms to get agencies to kind of fix things upstream. And I think that's one of the real challenges, I think, throughout the FOIA process, is how many things are broken before they get to the FOIA process itself. And that's a really hard problem to fix, the rest of everything going on in the system. So I think regarding the Cases Act, I think one of the really great discussions we had earlier was talking with some agency teams that are working on creating better form systems and better electronic submissions and standardizing that process across the federal government. And I think just getting more things in a standardized way and making sure that this data is segregated up front whenever possible would be really, really helpful. And to Bobby's point about sort of sometimes there's going to be reviews where you do have to disaggregate this data. That's true. I also think that, this has been a known issue for a long time. And I think we ask, under GDPR, every tech company in the world allows people to export all of their data. And they found ways to kind of uncommingle this stuff within a very short period of time after those laws were passed. And I think the federal government has had the FOIA laws for quite some time now, making sure that we're making this data easy to export and making sure that, when we develop systems that are going to impact these rights from the beginning, we don't say, oh, we're surprised that we're now getting FOIA requests for this, but find ways to do proactive disclosure. And I think that's the public's expectations. And I think it's not the FOIA office's fault that we haven't gotten there when it comes to first party requests. But it is a problem. And I think I think the public should expect more at this point of, if you're trying to get immigration files, if you're trying to get your own IRS files, for the government to say, oh, there might be sensitive stuff in there, we're going to have to take a year or months and months to get it back to you, I think is a pretty bad excuse in 2021.
Thank you, Michael. We've got lots of stuff to take back to the layer here.
Yeah, I see Kel has his hand up. Kel, can you promise to make it quick?
I'll try. It's not going to be super quick because it's sort of 2 points, but it's something that when we're talking about setting up new processes, I think that, it's very important to ensure that whatever process is set up for an agency, whether it be, regards to the agency, have at least the same informational guarantees as FOIA and at least the same rights. Because what we don't want to see happen is what happens a lot. For instance, you can go and request your file from some OIGs without a FOIA request. You can just say, I'm involved. I am the target of this investigation, or I am the complainant. I want a copy of the file, and you can sometimes get that, and the redactions in there will differ wildly from what you would get if you filed a FOIA request for it. And often they would redact things that you can't withhold under FOIA. And they'll say, well, you can't go to court to get information. So if there is any mechanism for withholding of information, any process for first-party requests must give the same limitations on exemptions and same appeal rights and same court rights as FOIA, or else you're taking a step backwards. And the second thing, to the point of the person who said, that some people treat it as a FOIA request. This happens a lot with consultations as well. Even if you have an agency that has an alternative method, for instance, you're doing a security clearance appeal, you're entitled to your investigative file by just asking for it, and the agency's supposed to give it to you. Even if you have an agency that does that, if they find a record that, say, belongs to ICE, they will refer that document over to ICE, and ICE will treat it as a FOIA request. So this can't just be the agencies that get first-party requests. There must be a guarantee that if I, as an agency, have a first-party request system, then I'm either going to process other agency equities through that system, or it must guarantee that other agencies that I do refer things out to also treat it differently, or else you're going to end up with this sort of quagmire where you're still stuck in FOIA, even though the agency you're dealing with is actually doing it right because everybody else isn't.
Thank you. Thanks, Carl.
I just wanted to, I appreciate, Michael, your comments. I just wanted to say that I was not framing it as an excuse. And I think, I want us to be, obviously, I think what you would describe as what we all want. But I just want to emphasize that for this to be helpful as a recommendation, it's something that agencies can take action on. That addressing the challenges that they've faced, I think, is really important to getting to the solutions. So I think that just needs to be a part of this process. So I just want to make sure that it wasn't not necessarily framed as an excuse at all.
No, and I didn't mean to imply that you were making excuses. I think I do, and I think everybody on the committee does really understand those challenges. I also, make sure that we're kind of, and also I think, again, this isn't sort of a problem with the FOIA offices. This isn't a problem with the FOIA personnel and FOIA programs. This is a problem with sort of, IT modernization and data collection and places we could probably put data collection and everything else, which goes way, way beyond the scope of things under any specific individual's domain, except for maybe the executive.
All right, thank you very much for all of those comments. Just to speed things along, I do understand there's at least one agency person who would like to speak, and I believe their line has been unmuted. Amy Bennett, do you want to go ahead?
Yes, hi, thank you so much, Alina. And I believe that there might be one or two other agency people on the line. Fernando, I believe, was going to speak for ICE, so you might want to see if he signed in, and then either Tammy Meckley or somebody else from USCIS was also planning on joining today. I want to thank you all so much for the opportunity to review and comment on this draft paper and its recommendations. I'm responding to this proposal on behalf of the DHS Deputy Chief FOIA Officer and the DHS Privacy Office. The DHS Privacy Office, under the leadership of the Chief FOIA Officer, has responsibility for overseeing DHS FOIA operations and recommending methods to improve FOIA compliance. We share this working group's goal of providing better access to people who need their records from the Department of Homeland Security. I'm going to briefly share some of our major concerns with this paper as drafted. We are happy to follow up with the working group members after this meeting to discuss our concerns in greater detail and to collaborate on how we can meet our goal. I'm going to focus my remarks on our concerns about these recommendations with respect to access to immigration-related records in A files. While we are happy that the working group did talk to USCIS, the paper and its recommendations fail to take into account the unique nature of A files. A files are the legal custody of USCIS, but they contain records that originate in several other agencies and other DHS components. Some of these records include sensitive law enforcement and even national security information. The agreements and memorandums of understanding that the paper references USCIS uses to process records that originate in other agencies are not simple agreements or arrangements. For example, it took several years of negotiations between USCIS and ICE to reinstate a memorandum of understanding, enabling USCIS to process ICE pages in A files after the inadvertent release of ICE law enforcement information. The second issue with the draft paper and its recommendations relate to process. First, there's no real clear distinction on what is meant by providing access outside of FOIA. We appreciate the IRS's self-service model, and some DHS components have been able to adopt similar models to give people access to certain record sets. For example, CBP provides access to information in the I-94 form for U.S. visitors. However, the example of SSA using non-FOIA personnel through its Skillsoft portal to review and apply Privacy Act and FOIA exemptions does not seem to fit in the same category. While it does seem like a good way to expand the FOIA workforce, an agency employee is still doing FOIA work. Given the unique nature of A files and the sensitive law enforcement and national security information in these files, A files similarly will still need to be reviewed prior to release. It may be possible to reformulate some of these records to separate out what can be released from what cannot, but some of these records cannot. They are not created in any sort of a way to make personal access to the records possible. They're investigative records or other types. They serve some other purpose other than the person whose information is in those records. DHS has explored shifting responsibility for providing access to A files to other employees without success. For example, I understand ICE ran a pilot project exploring whether its attorneys could make the records available to people in removal proceedings. ICE's attorneys were not able to pick up these responsibilities, and the pilot was ended. We understand the concern that given the volume of A file requests and the Nightingale court order, the department privileges these requests over other types of requests. First, I will note that USCIS has a specialized team, the Significant Interest Group, that focuses on processing non-A file requests. Other components that receive a large volume of first-party requests, including the DHS Privacy Office, have teams and processes in place to ensure that complex FOIA requests are not ignored. The DHS Privacy Office issues FOIA performance metrics for components that make it clear ignoring complex requests is not acceptable. We track and monitor the percentage of requests that are more than 200 days old and updated our metrics in this fiscal year to also require that components send out interim responses to older requests. Finally, we can't talk about the issue about this issue without also bringing up the dreaded topic of resources. DHS FOIA has particular expertise in processing records requests and applying exemptions. We have also worked continually to improve our processes and increase the productivity of our workforce. We know that there's more work to do, and we welcome suggestions for how to improve our performance. There is a real concern, though, that moving responsibility for responding to A files moving this responsibility outside of the FOIA office. First, the resources needed to do the work will not stay in the FOIA office once the work leaves. Second, whatever office the responsibility is moved to will need time to develop the kinds of processes and expertise we already have in place, and may end up costing taxpayers more while providing less customer service. And finally, DHS FOIA will no longer have access to the resources necessary to train up our FOIA professionals and develop a workforce that has capacity to handle the kinds of difficult and complex requests we also receive. Again, we really appreciate the opportunity to comment on the proposal today, and we really do want to work with you all on reformatting the recommendations in a way that is useful for everyone. Thank you.
Thank you, Amy. We really appreciate your comments.
Are there any other agency folks who want to chime in? Okay, not hearing anyone else. Any other comments or questions from the committee members to each other or to any of the comments that have been offered so far? Or should we move on to the next subcommittee presentation?
Could I ask a question in response to that comment?
Yes, who is this?
This is Alexandra Perloff.
Oh, thanks.
As the media representative, but also someone who does immigration law. What percentage of A files do have material redacted before disclosure? Is that the majority, or is that an unusual case that there would be the need to redact or remove national security or other protected information?
I believe the last time I talked to USCIS, it's practically every A file request has at least some information that needs to be redacted, be it the name of an interviewing officer or other kinds of information, but practically every A file request does involve redactions.
Thank you.
Hi, this is Cal. No, this is my. Sorry, Elena just asked me a question in the chat. The item that I want to just point out very briefly before we sort of move on to this is to respond both to that answer and to something that Amy had said before. To the most recent thing, sort of question about the redactions. I want to caution everybody who's talking about a proposal like this to assume that all these redactions are valid. It is a dangerous idea to assume that we shouldn't do a program because ICE redacts a bunch of stuff. To say we shouldn't do a program because ICE redacts a bunch of stuff because it assumes that all of ICE's redactions are valid and that the majority of things where they redact things, they should be redacting them. And this is, at least with ICE, I can say with expertise, is not always the case. And ICE, for instance, redacts a lot of stuff that is not properly redacted, and when challenged and sued, they often unredact it. So that is the first point I want to sort of caution I want to make. On the resources issue, I would just like to say that, yes, agencies need more FOIA resources. If DHS had enough resources to have a fully functional FOIA shop that did everything that it needed to do in a timely fashion, we probably wouldn't be asking for an alternative to get away from the tremendous FOIA backlog at DHS. So this is going to be an issue one way or the other. I think if the question is giving money to DHS's FOIA office to do more FOIA stuff and giving money to a separate office or a separate division of DHS's FOIA department to do first-party requests, those are both involving giving money to DHS and other agencies. And so don't go away. Sorry, my phone is ringing. And so that is going to be a problem regardless of what we talk about, but we should not be hung up on, well, don't do a program because it requires more resources, when the reason for the problem is that the resources aren't being used and aren't being made available to the FOIA office.
Okay, thanks, Cal. All right, I'm not seeing any other hands. Roger, is that you waving at me?
Yes. This is...
Could I briefly respond to some of Kel's comments?
Sure.
Okay.
And then I'll let Roger go. Yes.
Sure. So, Kel, with respect to the redactions, point taken. We, our exemptions are challenged in court all the time. For us, that's another reason that these records need to be kept in FOIA, where we can have a discussion in the court about whether or not exemptions are reasonable and appropriately taken. The other point on that is the flip side of the coin is that there is an assumption that all of our redactions, not just here at DHS but across the government, should not be made. And I think that especially given the sensitivity of some of the information in A files, that's a really dangerous path to go down. Secondly, with respect to the comment about resources, we try to be really good stewards of the public's money, and we take our responsibility to provide access, both to people who are looking for their own records and to other FOIA requesters really seriously. At DHS Privacy, we have put together a 3-year backlog reduction plan that really looks at what are the holistic problems with our operations, and has laid out a blueprint for how we can address those problems. We don't believe in just throwing money at the problem, because it's been shown over and over again that you can throw money at the problem for 1 year and fix it temporarily, but you're going to have a problem again in the next 1 to 2 years. So, we really are trying to have a thoughtful approach to how we can be good stewards of the taxpayers' dollars and improve our responsiveness to FOIA requests. So thank you for allowing me to respond.
Sure. Okay, Roger, go ahead.
I just wanted to clarify and make sure we're clear that the working group was just basically suggesting or recommending that all agencies identify commonly requested documents that might be much easier provided in an alternative process. Now, in your specifically discussing A files, the working group, I used to work at the USCIS, is not suggesting that A files as a whole A file should be considered as a first party request, even though it is, and that should have an alternative process. What we would recommend to USCIS would be, within an A file, look for commonly requested records within that A file that requesters are seeking. For example, you mentioned an I-94 for CBP. That's an example of a specific document people request for, which other than CBP come with the process would have had to be requested to the FOIA. So that's basically what we're trying to suggest here is look at documents within that your agencies provides to requesters and say, hey, within whether it's Veterans Affairs, EOIR, EEOC, wherever, we have certain specific documents which probably would have the least amount of redactions, okay, that we can release to requesters outside the FOIA process. I know, for example, Tammy Meckley mentioned that USCIS has set up what they refer to as the My USCIS, which allows people to submit forms electronically for certain benefits. That is a step in the right direction, because that provides people an opportunity to now have a portal where they have access to documents that they have submitted to the government, that they don't have to make a request for those documents. The issue is USCIS has not extended that My USCIS portal to all forms. They've just started the process. So yes, part of the recommendations is to push agencies into either getting more resources, more funding to get documents in electronic format to make it easier to provide them to requesters. For example, ECAS has now come out. ECAS is now a system that allows folks in removal proceedings who are going before the Board of Immigration Appeals to get access to their IRPs. Prior to that, they had to make a FOIA request for those documents. Now with ECAS, if you have access to ECAS, you don't have to make a FOIA request for IRP. That is what we are talking about. And we certainly are looking forward to working with DHS and other components with regard to how we can make our work better. Specifically with regard to the CASE Act, which I think we didn't really focus on submissions because I don't think the issue of paper submissions is a problem. I think most requesters are submitting for a request online. Either, I know, for example, USCIS has their portals, ER has a portal. So I don't think paper submissions is an issue. I think the issue is, and again, Michael said this, a lot of the problems happen before it gets to FOIA. A lot of records are created in paper. They're not in electronic formats, which means that they're dispersed all over the place. It makes it difficult to collect these documents. It makes it difficult to collect them. It makes it difficult to process them. It makes it difficult to release them. So we should be looking at how do we make sure that most records are in an electronic format where you don't have to move papers around, where it makes it easier for access to the documents. Because once we take care of those things, then making disclosures becomes much easier.
Again, Alina, if I could just briefly respond to the comments. Roger, we appreciate the clarification about the purpose. That is, and we're happy to talk about specific files or forms that we can make, better available to the public. We certainly have done a lot of work in that area. And I'll say that, we are generally providing access to all records, kind of the first party requests in about 30 working days. But, I'll also say that that's not the way that the recommendation is currently written. It talks a lot about USCIS and in particular access to A files through a non FOIA purpose. So, that might be something that just needs to be clarified within the recommendation. Secondly, with respect to your point about paper, I think that's a really good point. And certainly, it's in the government's interest to begin collecting and keeping paper in an electronic format. I would note, though, that the legal format for A files in particular is paper for a variety of reasons, including some that people at the National Archives would be much better suited to speaking to other than me. So that might be another, if the committee is interested in going in this direction, another area where a little bit more work needs to be done in terms of why is the government keeping information in a paper-based system in the 21st century. It's not just because we don't like change.
All right, thanks, Amy. I saw that Tuan had his hand up and then he respectfully took it down. Tuan, do you want to add anything to the discussion?
I was just going to say that, I think technology provides a lot of opportunities, of course, as well as risks. But, sometimes we can learn from newer countries and smaller countries. And I'm just thinking about Estonia and what an amazing example it has been, where 99% of its services are available online with documents being generated natively, electronically. And Alexander Howard has posted several comments that are very helpful in the chat, including referencing, the ability to get data that's very sensitive, health-related data. And these self-service portals really provide effectively a FOIA force multiplier in the sense that, the citizen is able to get access to this material and is able to help themselves. And so I do think that it is worth thinking about how going forward, portals might work. And the other comment I think that Alexander had made was that perhaps we also need to think about how A files are created, because I don't know. Again, if we have a repeated redaction need to remove the names of a particular, interviewing asylum officers, I just wonder if there are alternative ways to sort of generate the documents so that you don't have to create that work that you have to later go in and do. Again, I think there may be ways to expedite this. And given Mike Morrissey's point earlier about GDPR compliance, it seems like we can certainly do this.
Okay, thanks, Tuan. I really appreciate it. I'm interested in trying to wrap up this conversation only for today, because I think we need to continue. I think this will get carried over to our next meeting. Lots to think about, Alexis and the working group. And I want to thank both Michael and Alexis as the subcommittee co-chairs for leading this, and to be continued. So thank you very much for everyone's thoughtful comments. I want to give the legislation subcommittee a brief opportunity to do a quick report out before we turn to public comments. I understand AJ and David Collier wanted to give some comments. So AJ, do you want to go first?
Sure thing. I will be exceptionally brief. I will just give you the quickest overview of a survey that we have out there. I've just posted it in the link to it in the chat. It has been put together by myself, Dr. David Collier, and Michael Morrissey. There's been 2 rounds of sampling thus far. The first round of sampling, we worked with Michael and some muckrock requesters. So we have certified or verified requesters responding, and now we're into the second phase of the sample where we've tossed it out to anybody. So this is where I ask you folks if you know any distribution methods to get this in front of people that have taken or submitted FOI requests, whether state, local, or federal. It would be greatly appreciated. This survey is designed to serve 2 purposes. Obviously, we are here to serve subcommittee questions, but also to do a little bit of scholarly work as well for Dr. Dave Collier and myself. And we sought feedback and input from the committee, and we received a lot of helpful notes from a number of the committee members. Some of the subjects in the survey include OGIS authority. There's quite a few questions on fees, metadata concerns, FOIA logs, applying FOIA to legislature and judiciary, first person requesting, websites, across the board, lots of stuff that we're interested in across our various subcommittees. There's also some scholarly stuff in there that Dave and I are interested in as far as experiences, behaviors by requester category, demographics, government type stuff of that nature. As I mentioned, it's still active and we're still looking to reach as wide of an audience as possible. We're not quite as far along as we'd like to be as far as number of respondents. So again, any help is greatly appreciated. I'm happy to answer any questions you may have regarding the survey. But that's about all I have as far as just a very brief recap.
AJ, do you mind if I ask, is there a deadline for the survey? Does it close by a certain date?
Yes, this current round will close on Monday, December 13th.
Is there a chance that you might be able to extend that deadline?
Absolutely.
Okay. All right. Good to know. Thank you. David, are you on? Would you like to say a few words about the work you've been doing?
Yeah. Can you hear me, Alina?
Yes, absolutely.
Okay, great. Thank you. Yeah, I'm David Collier, an associate professor at the University of Arizona and president of the National Freedom of Information Coalition. And I'm joined in this working group by AJ and Tom Sussman and Patricia Webb. Now, we've been gathering information this fall to examine FOIA oversight models in the States and around the world to see if there are ways we might be able to improve the oversight structure within the U.S. FOIA system. While this working group has been labeled as reimagining OGIS, I think it's important to make it clear that we're not looking at the performance of OGIS or NARA or federal agencies. You know, I can't speak for others, but I believe OGIS has been a benefit to the country and that the 9 staff members work very hard. I can't imagine reimagining Alina, Kirsten, or anyone else at OGIS. So, in fact, one thing that's emerged from our research is that OGIS does a lot with very little. From the figures we've gathered so far on a per capita basis, OGIS is actually the most short-staffed office in the world. And that's even when compared to states, provinces, and cities. I mean, to put that in context, OGIS's staffing level is equivalent to FOI mediation agencies in Israel and the Yukon Territory. And staffing levels are greater among at least 40 other jurisdictions, including Connecticut with 16 staffers, Philippines at 41, Peru 780, Brazil 2,200. I mean, surely, we could do better here. So far, we've talked to dozens of experts and gleaned a lot of research, and we're seeing consistent themes when it comes to ideal structures, particularly when it comes to an organization's independence, its authority, its resources. For example, more than 60 nations have oversight agencies that have the power to compel agencies to disclose records without a requester having to hire an attorney and going to court. And it's almost in all cases free. In some cases, agencies are provided more protections and independence from the executive branch, including in their budget. And some models include remedies within the judiciary to streamline the system and reduce litigation, including in the state of Ohio, for example. It seems to be working very well. A lot of really interesting practices out there we're looking at, and we hope to share a draft report at the beginning of this next year, January, spread around, get feedback, discussion before the March meeting, and we'd like to include the ideal model of what the perfect structure would look like. Understanding, that there could be some challenges getting that applied in any timely fashion, but would also probably include some short-term recommendations as well. While we work on this, we welcome further input, thoughts from the committee members, thoughts from anyone else. So if anybody wants to talk about this topic, I'd be happy to do so. Just reach out. Thank you.
All right, David, thank you so much. I'm just going to quickly ask if anyone has any questions for either AJ or David. They've been doing a lot of great work. I don't see any hands up in the chat. So I've asked everyone on the committee if they could stay a little past 1 o'clock. I know we have some public comments that we would want to receive, and most folks have the ability to stay a little past 1. I believe Michael Morrissey has to sign off at 1 p.m. So your homework assignment is to tune back in and read the transcript and watch the YouTube video later to see what you miss. Same goes for anyone else, but at this time, I just want to turn my attention to public comments. We look forward to hearing from any non-committee participants who have ideas or comments to share. We're capturing all oral comments in the transcript. Any member of the public may speak or otherwise address the committee, and we're going to go ahead and ask Michelle now, our event producer, is there anyone queued up on the telephone line? And would you be able to share instructions again, Michelle, as to how to call in on the telephone line, please?
Absolutely, Alina. So once again, ladies and gentlemen, as we enter into the public comment section, you can press the raise hand icon, which is above the chat panel. You'll see a little icon. And so that's how you can ask via Webex audio. If you are on the regular audio line, you will need to press #2 on your telephone line.
Okay.
Okay. So that's how you would get into the queue. And it looks like we do have somebody actually in queuing, and we do have Alexander Howard.
Okay. Alex, go ahead, please.
Hello, everybody. Thank you so much for hosting this public meeting on FOIA. I can't tell you how much I appreciate your commitment to these issues and your commitment to hosting these forums in public for the entire country to be able to hear the debate back and forth. These issues are really complicated, and the dedication that you all have shown to engaging with them is admirable. And as we head into, I hope, a season when the United States will be re-engaging on the United States commitments to the Open Government Partnership next year, it's worth noting that this committee exists because of the Second National Action Plan. And I hope that as we move forward, that will be reified as something that is valuable. I know that there are some challenges, though, with respect to getting these recommendations before Congress in a way that's actionable and gets them to be incorporated into reform. And I hope that you'll continue to be advocates internally and externally for agencies taking actions that don't require legislative action. And that, I think, is going to require a somewhat different public posture. And just some feedback on public engagement, it would be wonderful if the co-chair of the committee, the Department of Justice Office of Information Policy, would promote the fact that these things are happening using social media, press releases, and otherwise encouraging all of the different stakeholders that exist to know that this is something that's out there, and for all of the different people who were involved in the process to be more engaged in it. I know that it feels somewhat lonely to show up at the archives and see sparse attendance online. I think that's even more stark. What I wanted to say today, however, is a bit focused on something else, which is the sunsetting of FOIA Online. For a lot of people, that is how they engage with the federal government and FOIA. They go to foiaonline.gov, and dozens of agencies use it. As confirmed by OGIS, by OIP at DOJ, this is something that's going to be sunset over the next coming months. And I hope that the committee will use that as an opportunity to think about how FOIA should work online in ways that it doesn't currently. And I think today's discussion is a really useful articulation of that in terms of thinking about how and where access to people's personal files, personal data can and should be available to them safely and securely online using a lot of the existing pathways that I identified in chat. The thing that I think is a huge opportunity ahead of you all is to consider how and where FOIA.gov could and should work if there were an application programming interface on it that enabled third-party applications, a whole ecosystem of applications created by nonprofits or for-profit entities to be able to make and track FOIA requests that go into FOIA.gov and go to agencies. This is something that can and should, I think, be nurtured cooperatively through the different pathways that exist around data disclosures that exist elsewhere in federal government. If you look at the communities of practice that exist around categories of data at data.gov, the same kind of thing could and should be working at a FOIA.gov that's been rebuilt with the people it serves by the Office of Information Policy and the GSA's 18F team, using open standards based on a common schema for FOIA data that creates a much more open and collaborative process, and I would hope creates a different kind of role for the Federal FOIA Ombuds Office to help people through that process and sees where they're getting stuck in the delivery of this as a service. And it's my hope that you all won't just stop with having a showcase and promoting a showcase to vendors, that this is something that you'll actually be building with the stakeholders who make FOIA requests to ensure that FOIA.gov isn't just a place to get FOIA stats. It's a place that every American knows they can go to get information that is all right about a government or about ourselves if our information is within government. And I want to put this out in front of you all as a challenge. We're going to have a great opportunity in this next year to talk about open government, talk about democracy, talk about technology that improves democracy, as the president just talked about this morning, as this conversation we're having is global, and to learn from other nations where they've done this better, and to learn from American states and cities that are doing this better, that are explicitly connecting disclosures in FOIA reading rooms, quote unquote, with the kind of structured machine-readable disclosures we're seeing in open data. And the end result should be someone being able to go to FOIA.gov, doing a search, and have it go all across the reading rooms, go all across USData.gov, and then be able to see what's out there and what's missing. And for anyone to understand who's asked for these things before, instead of having the logs be obfuscated. And for Congress and GAO and the Ombuds offices and you all to have an ongoing, almost real-time dashboard to understand the state of compliance. And in theory, that should enable all of us to not have to wait for these governance processes to trickle through, but to be able to identify where and how there are stopping points in the process that are preventing people from exercising their rights, and frankly to see where there are stopping points in the bureaucracy which suggest that OIP should be pushing them much harder. Because I don't think anyone can argue with a straight face that what we have right now is good enough across the board. Thank you for hearing me out. Take care.
Thank you so much for your comment. We appreciate that. We are moving on to the next caller in queue.
Before we move on, can I just respond to that?
Your line is unmuted. You may go ahead.
Hold on one second, Michelle. I think Bobby wants to respond.
Yeah, a quick response.
I'm sorry, go ahead.
Lose my train of thought on it while I look at the question. I appreciate it. And Alex, it's good to hear your voice. I appreciate your comments. I just wanted to say, so many of the things that you mentioned are things that we're working on. The 10X team that, and I mentioned this at the CFO Council, we're really happy that we're working with a 10X team in phase 3 to do exactly as you said, make it so that we're searching across agency FOIA libraries in one location on FOIA.gov, and plugging in other places where records such as data.gov are available proactively. So the idea being that the requester goes to FOIA.gov, they can do a search, see what's out there across the government, even inform where they may make a request if that search doesn't suffice, make it so that they're satisfied with the records they're looking for. So we are doing that work. I think there's a lot of work to be done. There always will be a lot of work to be done, but we're working positively to build on FOIA.gov, and agencies are working to build on their proactive disclosures, and we're going to continue to support that. And also, just want to say that FOIA.gov, of course, is not just a site to go and see FOIA statistics. Back in 2010, when we launched it, that was the initial goal. But since then, we've added so much more to the site, including standardized forms for making a request. So requesters can go and make a request from FOIA.gov from a single location, and having landing pages for each agency to have specific information about their FOIA processing on that page so that it's all easily accessible. Their FOIA regulations, their FOIA reference handbooks. I can go on and on, so I won't monopolize the time, but I just wanted to say thank you for your comments. Certainly, that's the kind of feedback we want to get because we want to improve FOIA.gov. We're not resting on our laurels, but a lot of this stuff is stuff we're working on.
Bobby, thanks very much. Michelle, I understand there might be a couple of other callers who would like to offer some comments.
Yes, we do have Freddie Martinez on the line. Freddie, you may go ahead.
Hi, everyone. Thanks for having us here. I'm Freddie Martinez. I'm a policy analyst at Open the Government. And we're here, I thank you for having us because, I think this is a unique place where we can discuss some of the challenges that we've been seeing with FOIA right now. I know that we've spoken individually with members of the committee, members of the subcommittee, OIP, OGIS, and others, both publicly and privately, about some of the things that we're seeing. First, I guess the place to start is that, I think a lot of us in our community are surprised at the lack of commitment to transparency and FOIA in the first year of the administration, at least anything that we've seen publicly. For example, we've been waiting for almost a full year for a memo from the Attorney General on FOIA and how agencies should be complying with FOIA's presumption of openness. And while we appreciate that the White House gives independence to the Attorney General's office, if you look back in 2009, Attorney General Holder had a memo out about a month into the administration. At the same time, we saw President Obama had a day one memo on how agencies should be treating FOIA. And it's disappointing to see that we're almost a full year into a new administration and we haven't seen similar movement. And we've talked about this previously in other venues, but, I think we really want to see Attorney General Garland talking about how agencies should be maximizing proactive disclosure, reiterating that agencies have to treat discretionary exemptions as discretionary. Agencies should be directed to improve their customer service and the importance of communication, especially during remoteness. The other thing that we really want to see is that the Department of Justice really take a hard line on not defending agency officials who act in bad faith or in clear violation of the spirit of FOIA. For example, agencies seem to have a far different understanding of the word reasonable as it appears in the FOIA throughout the text, and many times it appears, and it seems to be quite different than what the dictionary definition of reasonable means. And, we would hope to see that the DOJ and agency lawyers under a new administration would revisit this policy. So those are just some ideas that we really think should be at the forefront of a new administration, and we haven't seen that reflected anywhere publicly. And the reason we bring these comments today is because we care deeply about the FOIA Advisory Committee's recommendation and hope that both Congress and the executive branch begin to seriously implement them. For example, we've hoped that OMB would more seriously implement the recommendation for adding line budget items for FOIA officers. This recommendation could be done through executive action. It doesn't have to depend on the White House. It doesn't have to depend on Congress. And we haven't seen any of those kinds of recommendations moving forward. And then finally, just a few other things. One thing that we had also hoped would have improved in the new administration is communication about FOIA in general. I know Alex Howard talked about the sunsetting of FOIA.gov, but that also was not communicated well to the public. I think someone from the subcommittee called it an announcement, but that description doesn't seem to fit. Many of us found out about the sunsetting through a listserv. We didn't find out through any kind of official channels, any kind of press release. In fact, when I heard about it, people were asking if this was true, and we thought it was innuendo. We thought it was people speculating because of how poor of a job the EPA did of communicating the reasons for the shutdown, what happens to open requests, what the new systems might be, when they'll be open, etc. And so that's just one example of frustrations we're seeing in the community. And then finally, we hope that Congress steps up in its role of providing oversight in FOIA. It's been about 5.5 years since we've had open hearings on agency compliance with FOIA, the public's view of how FOIA is working or not working. And we hope that Congress will move more quickly on just comprehensive FOIA oversight, reform, and improvement in general. Thanks.
Thanks, Freddie. I really appreciate that. Michelle, I know we have one more caller in queue. Should we open up that phone line, please?
We do. We have one more caller in queue. Caller, your line is unmuted. You may go ahead.
Yes, hi, everybody. This is Bob Hammond. Can you hear me okay?
Yes. Please go
Hello?
ahead.
Yeah.
Okay. Hey, I'm going to be extremely brief. The comments that I would make orally, I have placed into the panelist chat and also into YouTube, and I sent them by email. So those are records that have been presented to the committee. My understanding of the law is that they have to be included in the minutes. So with that understanding, what I'd like to say is most of my comments go to what's already been said, that the OGIS staff is magnificent. I mean, they're super people, but they are just so grossly underfunded that they cannot do their mission. You cannot mediate 4,600 cases in a year with 3 people. That's physically impossible. OGIS isn't doing it because they're not able to. When Congress established the requirements for OGIS and OIP, they didn't provide any additional funding. So I'm trying to work with Congress and others on that common goal. And so a lot of my public comments today show what happens when you're grossly underfunded. They're not meant to be mean to anybody, but I put them into the public domain because we just need to understand how grossly underfunded OGIS is. And I would say the same thing about OIP. Bobby doesn't complain a lot, but they're similarly just grossly underfunded for their compliance mission. So with that, I want to thank you all, and my many of my comments are posted, and I've put my email address on the cover slides of those. It's FOIAcompliance@gmail.com. So if anybody wants to contact me, please do, and I'll spend some time with you. Thank you very much. Great meeting.
Okay, thanks, Mr. Hammond. I believe Bobby wanted to address a couple of the comments that were made earlier. Bobby, do you want to go ahead and have the floor?
Yeah, thank you, Alina. And I just wanted to respond to Freddie, and I want to thank Freddie for joining the meeting and for his comments. We appreciate it. I just wanted to say that the department fully supports the furthering the purpose of the FOIA and all of the many of the principles that Freddie mentioned, particularly proactive disclosures. But the Attorney General emphasized the importance in public statements in his first full week, the first day of his first full week as Attorney General at our Sunshine Week event, emphasizing that without accountability, democracy is impossible, and democratic accountability requires the kind of transparency that FOIA makes possible. And recently, our Chief FOIA Officer Council meeting, a public or public chief FOIA council meeting, the Associate Attorney General of the United States emphasized or echoed that sentiment and emphasized the importance of FOIA, and in particular, being the CFO Council meeting the important role of leadership at agency and the CFOs in all aspects of FOIA administration. That to say, we're the department is committed to government-wide FOIA administration, and we're there's more to come, and we look forward to, and I look forward to continuing to work with Freddie, you, and the requester community as we advance these principles.
Okay, thanks, Bobby. I really appreciate that. I am very thankful for everyone staying over our allotted time today. I know we're 1:17. I'm just going to quickly wrap up. Thank all the committee members for all the great work that you've done so far. We're definitely in the home stretch through June of 2022, and I anticipate a really lively meeting in March of next year. While you're enjoying the holidays, please think about volunteering to be on the final report and recommendations working group next spring. This group works on the final report that the committee will be expected to vote on at the last meeting in June of 2022. Last term, the working group met weekly beginning in March to craft the final report. See Patricia Weth for insider tips on the fact that she loved it and survived and lived to tell about it. If you are interested, please let me and Kirsten know. So far, I have 0 volunteers. So please consider this a holiday gift to me and Kirsten. If you can volunteer, that would be great. Thanks to all of you for joining us today. I hope everyone and their families remain safe, healthy, and resilient. We will see each other again, most likely virtually, I predict, at our next meeting, Thursday, March 10th, 2022, starting at 10 a.m. And if anyone has any other comments, I'm happy to listen. Otherwise, I would like to call this meeting to a close. Any committee members have any other comments or questions? Okay, hearing none. Happy holidays, Happy New Year to all, and we stand adjourned. Thank you.
Thank you.
Thank you.